I'm Senator Randy Robertson. I'm the chair of the subcommittee on appropriations dealing with compensation. I was told that you never start out with an apology unless you have to, but I have to this morning. We're a few minutes late. My admin went to get in his car this morning and could not get it unlocked. So, but we're getting everything moving in the right direction. And I want to start this morning the way we start things normally in the Senate, and that's with a prayer. And I'd like to ask Senator Russ Goodman if he would be so kind as to open this meeting up with a prayer.
Y'all pray with me, please. Dear Heavenly Father, we just thank you for today, Lord. We thank you for loving us. We thank you for the gift of salvation. Lord, we just thank you for the opportunity to come together today, Lord, and do the people's business. And Lord, as we go about that, Lord, we just pray that you grant us wisdom and discernment as we go about the day, Lord. And we thank you for all your many blessings that you bestow upon us each and every day. In Jesus' holy name we pray. Amen.
Amen. And just for a point of clarification, it's good to have Senator Halpern here this morning. When I first sent the notice out, Senator Halpern thought, because it was April 1st and we had a 6 a.m. meeting, that I was being typical Randy Robertson. But I did have to correct her because the first notice she got, she thought said 6:30. But I'd much rather be in this building at 6 a.m. than 9 p.m. And that's always been my thing. I've never liked those late night meetings. And seem fresher. And to my friends in law enforcement and public safety, this is the end of the shift for us most times, as opposed to the beginning. But we're going to go through a few things this morning. I think when I first became aware and involved in compensation, I want to say it was maybe 4 years ago, and believe it or not, I have voted for compensation on 2 occasions, and we've gotten it through. And I know there's some folks here in the building and outside the building that think I absolutely oppose it, and that is not the case at all. But I just think there are better ways to do it, and I know I have friends over in the House that think the same thing, and we have got to find a way to do that. And I'm hoping today we can move a few steps closer to a resolution on how to do that, because I have grave concerns that this type of responsibility is placed in the hands of legislators who have limited information when we do this. And I've had the opportunity to meet some great people that are involved in the compensation process from the Secretary of State's office that appreciate the weight that this responsibility of compensation carries, but they do the absolute best job they can do based on the what I think a flawed system that has been established and used for many years here in the state of Georgia. And as I do everything, whether we talk about speed cameras, whether we talk about prisons or jails, we start everything off with an education for the members of the committee to understand the process better. This will be somewhat, I hope not, but I could see where this would be somewhat laborious or elementary for the attorneys in the room, that as we walk through the judicial process, most of you know that like the back of your hand, as does our GBI director and others who are career law enforcement professionals. But I think for us to be clear on the process and the good and the bad in the process, I think that's the best place to start. So I reached out to Pete Scandalakis and PAC the other day, and like any good leader, Pete delegated his responsibilities to Robert. So, Robert, if you'd come up and basically for the education of the committee. No, sir, up front, please. Yeah, I want y'all to be as comfortable as possible. And I've told everybody already, and some appreciate it and some just don't care, but there's coffee and there's chicken biscuits over my office for anybody that needs anything. I know it's early. Robert, if you will, if you'll introduce yourself, your position with PAC, and what I'd like for you to do, if you will, is take us all back to the beginning and explain the process that an individual goes through when they're charged. And I've yet to see a compensation resolution that did not involve a person charged with murder in some way, whether they were they were engaged somehow in that crime, or at least they were accused and convicted of being a part of a murder. So if you would talk through the process from arrest to the point where somebody could be here, and if in the Latin you use, if you could break it down a little bit for members of the committee, it would be greatly appreciated.
Thank you. My name is Robert Smith. I'm General Counsel at the Prosecuting Attorney's Council. Just if you've never heard about my background, after I graduated from Mercer Law School in 1998, I was a law clerk in the Brunswick Judicial Circuit for 2 years. I left there and went to work briefly at the Atlanta Judicial Circuit as an assistant district attorney, and then went to the Coweta County Solicitor's Office and prosecuted misdemeanor crimes for 2 years. I then went to the Attorney General's office and represented the executive branch for 5 years, and primarily in the public safety realm. My clients were the Department of Corrections, the Parole Board, Post Counsel, DNR, and a few other of those related agencies. After that, I left. After 5 years, I went to the Griffin Judicial Circuit and was an assistant district attorney for 7. And I've been with PAC now for about 8 years or so. To kind of walk you through the process of how how somebody gets to this point, or how a case begins. Start off with arrest, essentially. Through investigation, an agency, law enforcement agency, makes a determination that somebody has committed a crime. They obtain an arrest warrant, or they make an arrest without a warrant, and then go back and get their warrant later. Once the person's been arrested, there's a hearing of some type to determine whether or not they should be, the arrest was properly done, if the officer had probable cause, or to make the arrest. Usually it's in front of a magistrate judge. At that time, the case, the prosecuting office gets involved. We're usually the ones who represent the state at that preliminary hearing. After that determination's been done, right now, I recognize there's lots of bills that are pending, but as it is right now, I'm primarily going to focus on murder cases. The district attorney's office will then get the warrants and begin the process to determine what charges should be brought before the grand jury for an indictment. We will review the case file, work with either we have an investigator in the office, or work with our law enforcement partners who investigated the case to make sure we have enough evidence to obtain convictions for each count that we present to the grand jury. We will draft a proposed bill of indictment to go to the grand jury, but the grand jurors, and that's 23 randomly selected citizens of the county with very little input. Basically, it's the first 23 people on the list that are there are the ones that are impaneled for the grand jury, and we will present the case to the grand jury. The grand jurors have the option of making decisions as to each charge. Sometimes I've been instructed to add additional charges to a bill of indictment. Sometimes I've been told to remove them. And then the grand jury votes in secret without anyone present other than them as to whether or not a true bill should issue. Once the true bill has issued, or there's been a true bill, that person's now in an indictment, and there's a case number associated with that case. At that point, we try to negotiate the case, or it goes to trial.
Now, Robert, is it true that the grand jury does not have to return a true bill, that they can?
Yes, sir. They and it's at the grand jury, it's a one-sided affair. With the exception of when we're trying to indict a law enforcement officer, and law enforcement officers have a special privilege, the normal defendants don't have a representative in front of the grand jury. It's simply the prosecutor, the officer, or the citizen that we're calling to present the evidence. The evidentiary standard is very low. Hearsay is allowed. They are under oath, but for the most part, it's basically the grand jury is essentially providing confirmation that the charges are appropriate, that there is probable cause, and that we can go forward with these charges. There is no right for a defendant to be present. There's no right for a defendant to be there except for law enforcement. And like I said, law enforcement is special. They have a special statutory privilege at that point. But a normal defendant, they'll know they've been arrested, but they won't know they've been indicted until they get notice in the mail that they have a date to come up and be arraigned, which is when you're formally advised of your charges. And the 10-day clock begins to file motions for our obligation to provide discovery. If the defense opts in, they'll agree to send what they have when we send what we have. And we exchange our information. It's called discovery. We exchange that information back and forth. I liken it to when you teach a child how to play a card game for the first time. You play with your cards face up. Everybody sees what your hand is. And as the state, that's what we do. We're not allowed to surprise the defense. They're entitled to know everything we have. They're entitled to be able to talk to our witnesses, be able to test our experts. The burden is on us for pretty much everything. One or two little minor things or unusual situations. But for the most part, throughout the trial, it's our burden because it should be our burden. It should be the state's burden to have to prove these things. I'm not going to go into death notice cases. I'm just going to talk about regular murder, if that's okay, because there is a completely separate process involving death penalty cases.
Yes, I'll get into the capital cases.
So just talking about a normal murder, I hate to say normal murder case,
Right.
but a non-death notice murder case. That case will come up during the course of trial. Sometimes judges will want to try those cases first. They're usually the more complex cases. Usually they involve more witnesses. And honestly, a lot of times the person's being held without bail. The decision whether or not to grant someone bond is on the judge who's hearing the case. And for the most part, a lot of people who are facing murder cases are not at liberty. They're in jail, and there is a pressure on us to keep the cases that are in jail to take them first. The sheriff's in charge of housing the person. They are being restrained from their liberty. So if they are in fact not guilty, we need to let them get back to society and get on with their lives. There'll be a trial. Anywhere from a couple days, couple weeks, just it all depends on the nature of the case, what additional charges they're facing, how complex or how simple it is. At the end of the murder trial, jury will return a verdict of guilty or not guilty. There's some other decisions too. Not guilty by reason of insanity, guilty but with intellectual disability. I'm going to put those to the side as well. We're just going to talk about guilty, not guilty. If somebody's found not guilty, the case is over, never to be tried again. If they're found guilty, in Georgia, there's essentially two sentences that can be given for a murder conviction: life and life without the possibility of parole. The sentencing is done completely. The sentencing is done by the judge. There's we put aside that there's some times we have to do aggravating factors for sentencing, but when someone's found guilty, there is a second phase. There's a mitigation phase. And the defense is allowed to provide anything they want. Anything can be used to mitigate a sentence. Primarily for the state, our evidence of aggravation is going to be things about the nature of the crime, the defendant's criminal history. That's kind of pretty much what what we have and all we're going to be able to get into. The defense will be able to get in, and like I said, it's anything. It can be, as a third grader, they wrote a really nice essay about government. In high school, the person worked at the animal shelter. Anything can be used as mitigation, and that's fair. That's how it should be. Because if you're asking what the appropriate sentence is, the complete picture of the person, the defense is entitled to bring this up. Once the judge pronounces sentence, they right now have 30 days to file a notice of appeal. They also can ask for a new trial. And a new trial hearing, either that lawyer who represented them or a new lawyer comes in and essentially argues that there were errors, insufficient evidence, there was an error in trial. I forgot one, and I apologize, I forgot a step. After the jury returns its guilty verdict, the defense can ask the judge to override the jury's decision by the judge. The judge, here in Georgia, judges have the ability, it's called being the 13th juror. So a jury of 12 can come back and say guilty on all counts. A judge can look at it and go, no, not guilty. I'm going to find that there was insufficient evidence. It allows, we have to then try the case a second time. But the judges have the privilege and ability to override a jury's decision.
Robert, in your career, how many times have you seen a judge do that? Or I'm not asking for an exact number, but have you seen that happen?
Twice.
Twice, where a judge has pushed back against the juror's decision?
One time I had a judge say that he didn't believe the victim was credible because she didn't act the way that a true victim should have acted. The victim had Down syndrome. And the judge didn't understand what that meant.
Right.
So we tried that case again, and in less than 30 minutes, the jury convicted on rape and all the other accounts.
But that's not a common occurrence, is it, for the judge to override the jury?
It's not.
Yeah.
The other thing too, and just because of the nature of the evidence, because you've taken 12 people and gotten them to come to a unanimous decision. It's not 11 and 1. It's all 12 have come to the same decision. Once at the new trial hearing, if you have a new lawyer, that means you can then say your first lawyer was ineffective at a constitutional level. So trial strategies discussed, what decisions were made to bring witnesses forward or not bring a witness, or what resources were available to the defense. All of those things are on the table for the judge to look and say, well, there was a mistake made, there was an error, reverse the trial, and have a new trial. If the trial court or the judge decides that there hasn't been a mistake made, there hasn't been any errors that rise to the level of requiring the conviction to be overturned, the next step in a murder case at the current moment, I'm caveating a lot because there's things moving in the background. Murder cases are appealed to the Georgia Supreme Court.
Is this an automatic appeal in every murder case?
In every murder case.
Not just capital cases, but any murder case?
Right now.
Right.
Every murder case is appealed directly to the Supreme Court.
Without any action from the defense, right?
Oh, no. Once they're found guilty, they file,
Right.
and the motion for new trial is denied.
Right.
The next step is to file a notice of appeal, and that appeal goes to the Georgia Supreme
And that's the
Court.
responsibility of the defense attorney to do that, correct?
Yes.
Right.
And they have 30 days from the decision to deny the new trial to go to the Supreme Court. At the Supreme Court, the DA's office is responsible for filing a response. The defense counsel will file a brief, the DA's office will file a response, and the Attorney General's office. They have a separate unit that handles murder appeals. The AG's office will file a response as well. So you get two briefs. You get a brief from the DA's office, which is usually a little more victim-focused, a little more fact-focused, and then you have a brief from the AG's office, which usually is going to be more about the law, a little more clinical as to whether or not the case should or shouldn't be reversed.
And to that point, you said the DA's office is going to be more victim-centric. The AG's office is looking at the technicalities of law, in other words, to ensure that the individual received due process.
But, well, they're in the prospect of trying to defend the conviction as well.
Correct.
They're appealing on behalf of the state. They don't have, because they have not had the direct impact. We, primarily based on our relationship with the victims, will have had a lot more interaction with the victims. Usually, in some DA's offices, the person who tried the case is the person writing the appeal.
Right.
So there is a certain amount of investment.
But the DA's doing it from a ground level.
Yes,
and
sir.
the AG's office is doing it from 5,000 feet up, looking down at primarily the process to ensure that all the rights of the accused were followed and carried out, and and making sure the machine operated the way the machine should have operated. Would that be a fair statement?
That's fair. There is some discussion of the facts, but they are looking about that. And one of the reasons why the AG is getting involved at this point is because of what happens next.
Right.
But if the case gets set for oral argument in front of the Supreme Court, usually the DA's office are the ones who come up and argue the case in front of the Supreme Court. Obviously, the defense still is entitled to a lawyer. If they're indigent, it's someone still appointed someone appointed and paid for by the state. If they have resources, it's someone they've hired of their own means.
And how often is it that the attorney that's defending them or presenting the case in front of the Supremes is the same attorney that defended them in the courtroom?
It's rare. It's becoming more and more rare. Several years ago, there was a case where the Supreme Court said that the argument about ineffective assistance has to be raised as early as possible. So as a result, usually the trial lawyers are different than the appellate lawyers for the defendant. And the idea is that if there was ineffective assistance, and once again, and this is where I will admit the state's version or the state's belief of what it is ineffective and the defense bar are two different things. And the court usually sides with us that ineffectiveness is not based on the result. Ineffectiveness is more along the lines of whether or not the rights and the ability for the defense has been honored.
And how often, on average, is ineffective defense the argument after a guilty verdict?
I would say if it's not 100%, somewhere in the 90%.
So there's always going to be, it seems to be based on evidence that any appeal is going to start out with ineffective defense.
It's going to actually start out with insufficient evidence.
Right.
And then after insufficient evidence, the next thing is going to be ineffective assistance.
So those two things normally travel together. I mean, in almost 100% of any appeals. You said 100, I guess.
If it's not 100, it's in the high 90s.
Okay.
And that's because those are the things you have to raise. You have to raise insufficient evidence. You have to raise ineffective, because if you don't raise ineffective as early the first time you switch lawyers, the court can deem it waived.
Okay.
And you want if you're in the position of challenging your conviction, you want to argue as many things as possible.
So are we somewhat just checking boxes?
Sometimes we are. Sometimes there's a legitimate argument.
Right.
Sometimes it's a case of, well, there's this witness that didn't get called, and it comes down to a strategy. And that's a lot. That is one of the arguments, is that sometimes a defense attorney, yes, they wanted to call this witness, but if they called this witness, it would have undercut our alibi, our alibi argument. The defendants are allowed to argue contradictory evidence. Basically, I wasn't there, but if I wasn't there, somebody else did it, and if somebody else didn't do it, I was justified when I did it. A very skilled defense attorney will say, okay, those three things will confuse a jury, and want to go with just the best one of those three. Whereas someone's like, well, I truly want to throw as much against the wall, and if something sticks, then maybe a juror will pick up on it and acquit the person. And that is a strategy. That is an argument, and defense attorneys have a very difficult process in how to handle a client, how to handle clients' families, because you could possibly have those three contradictory defenses and have evidence for each one, and figuring out which one of those three is the best one to present at that time in the case. That's not an easy thing to do. Once the Supreme Court affirms the conviction, the Supreme Court can either affirm or reverse. If they reverse, the case goes back to the trial level and we start all over. Or they could come out right and say there's insufficient evidence. Usually if they're reversing, it's because there was a legal mistake made, a piece of evidence was admitted that shouldn't have been, or there's rarely, if ever, do we see insufficient evidence out of the Supreme Court when they reverse cases. Usually it's more along the lines of a legal mistake.
And when you say a legal mistake, are the vast majority of these unintentional technical errors, or do you find that the majority of them are prosecutorial misconduct or intentional actions by the prosecutor or the state, if you will, to basically, and thwart may be too strong of a word, but to thwart due process?
Usually not. And this is one of those times where you and I are going to probably have a different definition of that phrase. We're seeing reversals based on the fact that recently the state offered up evidence about the defendant's prior behavior. There was a case not too long ago where in a murder case, the fact that the defendant had done the same thing in a previous relationship to a different woman was introduced. And the Supreme Court said that was improper and that caused an error, so now we have to retry the case. So I wouldn't say that's prosecutorial misconduct.
Right.
That's just the case of that we looked and y'all have told us that we can introduce evidence under Rule 404B. And we thought we were introducing the appropriate evidence. The Supreme Court said no, it was not appropriate, and as a result, it prejudiced the case. We have to go back and try the case a second time.
And I think when I look at prosecutorial misconduct, I'm thinking of intent also, as you would another thing, where a prosecutor knew what he or she was doing was contrary to case law or whatever, but they went ahead with it anyway, or where they had evidence that would have been beneficial to the defendant. And you're talking about cards up, and they turned the card down, and therefore those things that seasoned prosecutors should know better than is what I would call the misconduct, where what you're talking about, if the judge has a decision, if there's an objection and the judge determines to the side of the prosecutor, and then it gets up to the Supremes, and the Supremes look at it and say, hey, you know what? The judge made the mistake there. That was not an intentional mistake by anybody. The judge felt that he or she was making the right decision at the time, and the Supremes get up there and bump it up against other case law and say, no, you know what? That should not have been allowed in the case, what you're talking about as far as, past conduct. And so that's not prosecutorial oversight necessarily. It's not even misconduct by the judge. It was a determination made by the judge that the Supreme Courts feel different about. And so it goes back, right?
Right.
Okay. But that's not prosecutorial misconduct.
I would say that there are cases, there are some times when we do make mistakes.
Not you yourself, but other people?
The prosecution family. I mean, I'm here on behalf of the council,
Exactly.
and I'm going to got to take the hit for everybody.
Got to take the hit for everybody. That's
And
right.
there are times when Brady does get violated. Brady
Yep.
versus Maryland's a case that says that if we have material information that can lead to either the defendant being not guilty or mitigate their charges, we have a duty to turn that over.
And we've had that happen in this state, right?
Yes.
I
we have.
know we paid a compensation out of some individuals in Savannah several years ago where the prosecutor intentionally hid discovery and did some other things, and it was a clear-cut case of violations, correct?
Yes.
So it does happen.
It does,
Yeah.
and that's once again that's one of the things that we every year do our best as part of our mandatory trainings is we try to hey, this is the rules about Brady. You've got to do this. One of the things that complicates it is that this notion of the state is the state is the state. So I am charged with knowing everything that my law enforcement partners know. So if there's an instance where I'm working with a case, it involves a police department, and that police department they have something that they know about one of the officers' credibility, or they know something about whether it actually was we arrested another person that night who gave a full confession. If they never tell me about it, if I never know about it, I'm still charged with knowing it, and I still will have violated Brady, and my conviction will still be overturned. So there have been instances where never even and information was intentionally shielded from the prosecutors. It still led to reversals of convictions. That is the way that the system works. So people I have no control over. I can't tell a police department or a sheriff's office, hey, you have to do this. I can encourage them strongly. I can tell them, hey, if I don't know about this, these are the consequences. But at the end, they report to a chief, they report to a sheriff. They're my partner, but they're not my employee. They're not my subordinate.
But their failure is your failure, whether it's intentional or unintentional, correct?
Yes, sir.
Yeah.
That's back to the whole notion of the state is the state is the state.
Right.
But for the most part, and you can look every other Tuesday or so, the Supreme Court will issue decisions. We're doing a pretty good job because the reversal rate's not a very high reversal rate for those things. Usually it's more about a misapplication of law, a piece of evidence, or something like that. Usually when there is a reversal based on Brady or something like that, it's big news. And we try to take steps to immediately, and when we do our trainings, this is something we've got to make sure we highlight. When we have the privilege to help train police officers, that's one of the things I explain to them is, hey, I get y'all y'all prefer sometimes for us to not have this information. You prefer us, there's a bill that I believe passed both chambers yesterday about Giglio information and how to handle that issue. That's, we recognize that we prefer not to put things on display. But the way the system is set up, if we make a mistake, a person walks free. That's the balance that has been struck. The goal is to hold the state to a high standard and make sure that we protect rights, we follow procedures, and if we don't, the consequences are somebody that we may believe and may have evidence is guilty of a crime will not be held accountable for that due to our error. Once the direct appeal is resolved, the Supreme Court has come back and said there was sufficient evidence, there were no legal errors, the conviction is affirmed. If the defendant wants to, they have the opportunity to apply to the U.S. Supreme Court for certiorari. That is akin to winning the lottery. The level of mistake that has to have been made, you have to show that other circuits there's been a dispute. I think 4 cases got taken last year by the U.S. Supreme Court involving state claims. For the most part, the state Supreme Court, the state Court of Appeals are basically the final arbiter of criminal rights. Our U.S. Supreme Court is moving further and further away from dealing with criminal aspects. They're dealing more and more with other issues. So the defendant now has exhausted what we call the direct appeal process. They're in prison, they're serving a life sentence or life without parole. They have essentially 2 years to file what's called a habeas corpus action. That's a civil action filed in the county in which they're being detained. They're in prison, so where the prisons are located, the courts there receive a high volume of cases filed by the defendants, filed by the inmates, saying that they're being illegally held. That's what habeas corpus, basically, it's a Latin phrase about you have the body, but what the case does is the cause of action tests whether or not the detention is legal. And there is no right to attorney at this point. So it's the defendant by himself or herself filing a civil action, and they're filing it against the warden. Now remember I mentioned that the Attorney General drops in to write that direct appeal on a murder case. The reason why, one of the reasons why, is that in habeas petitions, as long as the person is in custody, the Attorney General's office represents the warden and either someone who works directly here in Atlanta or they'll bring in somebody called a special assistant Attorney General who has a contract with the AG's office. They represent the warden in these habeas corpus actions.
And who do you say represents the defendant in the habeas corpus?
They do themselves.
So they file the action against the warden
Yes, sir.
of the institution they're being held in.
Yes, sir.
Right. And what normally is that action?
It's a habeas corpus.
Exactly.
Petition.
What is the habeas corpus petition challenge?
Everything.
Right.
Basically, I don't want to be glib and say that it's a relitigation of all the issues, but it is a relitigation of all the issues.
Issues that have been resolved prior?
Yes. Sometimes there's new ones. Sometimes it's, hey, I just found out this information and I'm bringing this forth the first time. Now, this isn't to say that those inmates are there by themselves on an island. I know the law schools have clinics where law students will work with them. There are law firms that will do free service in certain cases. There are some very fine organizations that also will pick up cases. They can be selective. They're not going to take every case, but if there's a certain case that, hey, this does sound like there's an issue here, they will come in and help. Some of those are wonderful people to work with. Others, when you have a law firm from New York City come down and set up shop because they believe that this person is not guilty. I remember a case where, I'm specifically talking about a case where a New York law firm dispatched 4 lawyers and their team. They set up shop in a courthouse. They brought their own printer because the printer in the clerk's office wasn't fast enough for them. Those resources can get poured into a case, investigated, and they will be able to argue about whether or not the person was not guilty of the crime or innocent.
And these are law firms you're referencing. These are law firms that come in and support these individuals being housed in the Department of Corrections during habeas corpus
Yes.
petitions.
Yes.
And there are some very prominent law firms here in Atlanta that do pro bono work that do the same thing, right?
Yes.
Yeah.
And the idea is that they're donating their time for free. They're donating their services and providing, because the inmates, the defendants don't have legal representation, it's, an opportunity. And sometimes it's easier in that habeas instance when you have a lawyer across the way versus when you have a defendant. A defendant who doesn't always understand what the system is doing or how the system operates. There are certain things that it's not easy to explain to a layperson when they're caught up, even when they're personally caught up, personally invested. It helps having a legal team there.
Now, is there a pattern to habeas corpus petitions where, every petition is close to the same, the issues that they challenge and other things, or are they very unique? And I understand each case is unique, but as we talked about before, whether it's challenging the evidence, whether it's challenging the quality of defense that they had and all this, are those things fairly typical through the habeas corpus?
Those issues will be raised, and for the most, once again, those are the top 2 issues. There'll be other issues as well that'll be raised. Sometimes it'll be, hey, the law has changed, or hey, there's the Supreme Court said this, but actually there's these other cases, and what they're trying to do is they're trying to get the trial court, a Superior Court judge, to look at their case and go, well, okay, this is something that's different, or this is something that's changed, and as a result, we should grant a new trial.
So far in the process, are the convicted getting multiple bites at the apple based on the same challenges?
Yes, but that's the way the system's designed. To
Absolutely,
make sure,
yeah. But in other words, only in some cases, and we're all familiar with certain cases, everything they challenge at every level is the same thing they've challenged at the level before that has been denied?
Not the same, not always. There's usually some nuances. There's usually some things that are changed. Some new information may have been discovered or uncovered.
Right, and those situations do happen. But in the ineffective defense, the lack of evidence, are those fairly consistent throughout the process?
Usually, it's going to be yes.
Where we can say, well, the Supreme said that I don't have a challenge, but then again, in the next case, we offer up those same challenges.
I'll give an example. At the trial level, the defendant wanted to go with alibi. Instead, because there was a video of the events, his lawyer decided to argue justification instead. On direct appeal, after the first lawyer was fired and a new lawyer came in, it was raised as ineffective assistance that they went with, instead of going with alibi, they went with justification. The trial court said no, motion for new trial denied. On appeal to the Supreme Court, same issue was raised. Supreme Court said no, there was no error by the trial court to make that finding. On habeas now, what will be challenged is that the appellate lawyer was ineffective for the way they challenged the trial court's decision, the trial lawyer's decision which defense to raise. So it kind of starts becoming like Inception or The Matrix, that basically you just keep going further and further out with the same core issue, but you just keep going further and further out with your challenges.
And the more attorneys you use, the more opportunities, the more attorneys you use, the more appeals you lose, then you keep adding layers into ineffective counsel.
I'm currently working a case out of your circuit or your district that is on its 7th lawyer. And all 6 that have come previously are part of the ineffectiveness challenge. And what happens is that means when there's a hearing, all of those lawyers are under subpoena to come testify. And in the habeas petition, all those lawyers will have been questioned at some level as to why they did what they did, what was the decision, and trial strategy. Our courts have said trial strategy. If a decision is a reasonable trial strategy, defense attorneys are allowed to do that. It has to be a decision that no other attorney would reasonably have decided or done to do when they went to the trial, and that not very well said. But
So to be clear, how they measure that is if this is something that other attorneys would do, then the courts find that is not ineffective. But if it's some anomaly, something out in the wild that wouldn't typically be used, then there is a possibility that it impacted.
that's the first step.
Right.
That's the error, and then you have to show that decision caused the conviction. So there are certain times where they can say, yes, that was a mistake, but because that mistake was harmless or that mistake didn't ultimately lead to the outcome, then they're not going to reverse the conviction. Overwhelming evidence of guilt is usually one of the ways they can say, yeah, there was a mistake made. The court will say there was a mistake made, but that mistake didn't ultimately lead to the outcome because there was so much else at stake. Once during the habeas process, and the habeas will take years. It's not whereas the process I've talked about, you get the arrest, you get the trial. That can happen in a short period of time. It can happen in a long period of time, and there's a lot of factors that go into that. But once the appeal process starts, you'll get a decision out of the Supreme Court within 2 terms. So that's about it. Basically, once the conviction is handed down, it could be about a year or so before the case is over. Once the habeas process begins, it has a life of its own. It could take years before it gets resolved.
And why is that?
You have to have all the lawyers present. There's a certain aspect of trying to discover and get the information that's needed.
Now, you say all lawyers present. That's if one of your contentions in habeas corpus is ineffective counsel?
Yes.
Okay.
So you're bringing lawyers from all over the state down to a court where the defendant's housed by the Department of Corrections.
Right.
At that point, it's the petitioner. And that you're trying to balance people's schedules. It's not always an easy thing or a thing to arrange. Once the habeas process is resolved at the trial level, they then can file a certificate of probable cause asking for the Supreme Court to take up the issue and to review the habeas petition. Once the Supreme Court either declines or does accept and affirms, they then file a federal habeas. And at the federal level, and usually one of the things the federal habeas petition is looking for is to see if these claims have been raised at state proceedings. Usually they're looking to make sure everything's been exhausted through the state process, and that it's the first time you bring these claims. It's not a successive claim. Federal habeases are filed in one of our 3 federal districts. Georgia's divided at the state level into 51 judicial circuits. The 159 counties are broken up. Some circuits are as small as 1 county. Other circuits are as large as 7 or 8. At the federal level, we're divided into 3 districts. We're at the northern, middle, and southern. Northern is Atlanta, goes down to Noonan, up to Rome, over to Gainesville. The middle goes from Athens down to Thomasville, has Macon, Columbus, and I'm trying to remember where the other one is. I think Tifton, maybe. Oh no, Albany. That's where the offices are located. And then the southern is Waycross, Brunswick, Savannah, and Augusta. And you file your petition in one of those courts, goes through the federal process, and then ultimately it's reviewed by the 11th Circuit and the U.S. Supreme Court. We do have, after that's all over and said and done with, after you've exhausted your federal habeas, your state habeas, that doesn't mean the person can't keep filing petitions. They have to be able to show that there's something new, something novel. We also have
Help me, what is novel?
brand new. It's an idea.
No, I understand, but I understand new. Novel seems unique.
That the court has changed. The law has changed.
Okay.
And that basically something that was done, something like a new process that they didn't have access to. There's now a new process created by the legislature.
Say a new way of testing DNA or something like that could be considered novel?
Or a new standard in how we judge certain things. A defense that wasn't available, that's now available. Okay. Those things can be raised. We also have our extraordinary motion for new trial based on DNA evidence. If DNA is uncovered or there's ability to test, and our testing, the science behind how we test DNA has grown by leaps and bounds. There's things that are now that we use that are widely accepted here in Georgia that 15, 20 years ago were unheard of. So there are opportunities there for someone to say, hey, there was DNA testing, the match was one in however many. The testing now is even more specific, and if they meet the proper standards, they have the opportunity to have that DNA testing done. And that isn't to say that it isn't a stop. You can keep filing petitions. You can keep filing habeas petitions, but the presumption is that you've had your one habeas petition. A successive petition will not be allowed unless there is something that requires it to be heard.
And those decisions are made by judges, right?
Trial judges.
Right.
That's one of the things you probably have heard about with the judicial studies and also from us. The counties where prisons are at have a large number of prison litigation. They also have a large number of cases. And somebody has to respond to those cases. Somebody has to, for the judges. Judges have to hear those cases and have to adjudicate them. Usually, if it's going to involve somebody from the AG's office coming down from Atlanta, or somebody who's local handling the case down there.
So let's say someone gets into the habeas process, and the court determines that there is something, and the case is sent back.
Yes.
All the way down the ladder to the trial court, right?
Yes.
Okay. And what is the process there?
So let's take a case, an extreme case. The U.S. Supreme Court reverses a conviction. Basically, they found that there was on habeas. They grant the habeas. That means the case comes back down to the DA, and in some cases it might be the same DA who prosecuted the case, or it might be 2, 3, 4 administrations later. We have to take the file out of archives. We have to reevaluate the evidence and determine whether or not we have enough to go forward.
Now, what makes that determination if you have enough to go forward, if you had enough to go forward to begin with?
Things have changed. Witnesses are no longer available because, like, for instance, trying a child molestation case and your victim is 14 years old. When you try the case later and she or he is now 35, the evidence is going to be viewed a different way by a jury. And that's just natural, that we can't find another child to sit at the stand and represent that evidence. It's going to be the victim once again, and things, they look different. They sound different. Things change because your officer who was your lead detective is no longer with us, retired or deceased. How does that evidence come across? Because in some instances, what you do is you end up reading the transcript. But if one of the reasons why the reversal was based on something that was said or something that was done, that evidence and that witness are no longer available to you.
So does that put the prosecution at a disadvantage?
I wouldn't say disadvantage, it puts us at a challenge.
Okay, and so why do we see null process come at, or prosecutors refusing to prosecute?
I wouldn't say they refuse to prosecute. Sometimes it's just
Excuse me, they choose not to prosecute.
On a case that's been reversed.
Right, a case like you're talking about, the child molestation case, where you go from a 14-year-old to a 35-year-old. What would be a reasonable, in your experience, and I appreciate the emotional impact a 14-year-old in court testifying to that they were molested, as opposed to a 35-year-old coming into the courtroom at the same time. So the prosecutorial mindset, if you will, going into there is the prosecutor has to make that decision, right?
They have to make that decision. They have to balance, putting the victim back through another trial, because in some cases they've been able to heal, and suddenly you're reopening the wounds again and having to talk about their abuse. And there are, some people say that's very cathartic. It helps empower. It helps the healing process. Others, you're re-victimizing. So that's one of the things you have to take into consideration. Another is witness availability. If sentence has been changed, and the sentence ranges are no longer the same, or the measure of the evidence, the shifting notions of the community. If basically the evidence that you could put up 20 years ago to lead to a conviction, now honestly, there's certain kinds of cases that when I was prosecuting misdemeanor cases, we could get convictions on. Now it's a lot more difficult because of just how our community notions have shifted.
You want mores and just what the community is willing to accept?
Yes.
Okay.
Because there's some communities that certain things now are tolerated, even though they are illegal, and we're caught in the mindset of, okay, what do we do with that?
Okay, so in using that as an example, if you as a prosecutor say that the community standard is different than it was then, and so you choose not to retry that case, are you saying that person is innocent? Because I mean, when you say null pros, I think isn't there times an assumption, and this is just I don't even know if it would be an opinion, but that when you say null pros, you're not necessarily, are you saying that the person's innocent, or are you saying that the climate has changed now to where it would be a waste of resources to retry this person? Or are you saying that even though I know this person is guilty, it would not be responsible to retry this person?
There's different levels of a null pros. There's sometimes I've read a null pros that basically there's insufficient evidence to obtain a conviction beyond reasonable doubt.
And this is on a habeas?
Or on any kind
Well,
of
no,
case.
I understand. I'm not talking about a fresh
Okay.
null pros, early in the process. I'm talking about when a case comes back on a habeas.
I'm going to have, I hate to, I know I'm here, and
Your opinion matters to either side. This is not
having never been an elected official, there's a certain amount of pressure there too, because I serve the community, but I also serve the community at the pleasure of somebody who has to stand in front of the voters every 4 years.
right.
So that is something that I respect the heck out of the DAs and solicitors who have to make those decisions, and that's. If I had a case that got reversed, I would sit in my boss's office and let him or her make the ultimate decision. And I know they would have my back, but ultimately it's up to them. And sometimes those no processes are crafted to say that, and I'm aware of cases where the DNA's come back and exonerated the person. Well, obviously that's when you write down this person is not guilty because the DNA proves that they were not the perpetrator. There's other times where we no longer have sufficient evidence to be able to obtain a verdict beyond reasonable
And you
doubt.
said we no longer have sufficient evidence, but is that's not saying we didn't have sufficient evidence at the beginning, on the front end?
That's how I would interpret that, is that at some
Right.
point we had it, because obviously we did. A jury came back and convicted.
So is exoneration, what is exoneration based on, or should be based on? Should it be based on real evidence? Or is an exoneration coming back 15, 20 years later saying, hey, you know what, 3 witnesses we cannot find, this has happened, that's happened. So is that and I'm not trying to paint you in a corner, because I've asked people, I don't know that I've asked anybody smarter than you. I've asked a whole lot of people a lot smarter than me what the definition of exoneration is, and pointed out that the Black's Law Dictionary that I used at the police academy was only about this thick. The ones that my esteemed friends that are attorneys use much larger volume of the law dictionary. So am I just playing semantics with the word exoneration, or is there not a clear definition of what exoneration is?
I think there's not a clear definition, and I think that the exoneration is a rather big umbrella. That some people were exonerated because they are, the DNA says they didn't do it. Some people were exonerated because, and I'm trying, and this is one of the things I'm trying not to paint too broadly as well, but
Well, there was a case in Savannah where the primary witness comes back later and says, you know what, I lied, and here's why I lied, and laid it out there. And I think that was a clear case of exoneration, that the biggest piece of evidence they had stepped forward and said, you know what, I was trying to prevent a problem, and to prevent that problem, I falsely accused this person of doing this, but they didn't do it.
and there's a video that's uncovered that shows that the description of the person doesn't match the physical attributes of the person who was convicted. Those are I guess this is one of those times where I kind of you define. You're the ones who define words in our code. For me, the exonerations are when you show that this person is, yes, they're not guilty.
Exoneration is when we show this person is innocent.
There was a mistake was made, that we presented evidence, and the evidence it's not evidence beyond all doubt. It's beyond a doubt upon which a reason can be given, beyond a reasonable doubt. So occasionally we're going to get it wrong. And in those occasions, something has to be done for those folks. I guess having been on the other side of having cases reversed for various reasons, when a conviction gets reversed for a legal reason, or for legal, as long as it's not, for me, as long as it's not a factual reason, I don't look at it as it being the person's been exonerated. They've just been maybe absolved. Maybe that's a better word to say. That I view them as no longer guilty because the jury. I had a case where the argument was whether or not they were a fiduciary and in theft. The Court of Appeals came back and said that the evidence, that they changed the definition of what a fiduciary is. The conviction got reversed. Didn't mean that the person didn't take the money. All it meant was they didn't take it as a fiduciary, and since I charged them as a fiduciary, they were not guilty of the crime with which they were charged and released, and I couldn't try them a second time.
So they committed the crime that you accused them of committing, but it was just a technicality that basically.
I would agree with you. Technicality. The attorney who represented them, I think, would use a much stronger word than mere technicality. But yes.
Sure, and something else we were talking about before, when we were talking about exoneration and things like that, or the strong evidence that would come back and lead to a null pros, is intentional prosecutorial misconduct. And I want to be clear on prosecutorial misconduct. it's a law enforcement officer perjuring themselves on the stand, because you said the state is the state is the state. So a law enforcement officer planting evidence, a law enforcement officer lying, somebody along the prosecutorial line turning the cards over so that the defense cannot see.
A judge making an intentionally wrong decision.
Exactly. And these are crimes. I mean, very well can be. I know perjury is a crime, and I know there's the JQC and others that can look at judicial conduct and address things of that nature. But these are not unintentional, and I use the word technical a lot. I think maybe too much, but these are unintentional actions taken. In other words, when the judge made a decision, he or she felt strongly that that was the right decision. When the prosecutor said something in closing that the court sends back and says, yeah, the jury should not have been told that particular thing. Or I think we have a case that we may talk about here today later of unintentional juror misconduct, where a juror calls somebody they're not supposed to call, read something they were told they weren't supposed to read, sat down and watched the 6 o'clock news during a trial when they were asked to stay away from all media, those kind of things, and then they go back and share with the other jurors this, and it taints the minds of the jurors. While those are in cases have been shown to be reversible actions, there was no intent by the people involved in some of these cases to mess the trial up, right?
Some of them, yes, some of the people don't quite recognize the consequences of what they're doing. They think that it's okay. I don't think anyone ever sets out to intentionally mess up a trial. I may be proven wrong by some of the actions of some, but I don't think anyone ever. I think there is a certain level of respect about the process because of what's at stake. But our system doesn't have a fine line distinction between intentional acts of misconduct or not. Basically, an error is an error. If it's harmful, it leads to a reversal. And we don't have so we don't have this. With these errors are not as bad as these errors, or it's an error that causes it's reversible, means we start over.
But an error is not always exoneration, right?
Yes.
It doesn't always lead to exoneration, correct?
I would agree. Errors do not always lead to exoneration. Errors can lead to new trials, which can lead to the same results, or they can lead to a different result.
Right. And when it comes back, and we'll use 15 years as a benchmark, if the case comes back 15 years later based on any of those, and the prosecutor is able to build the same case, no matter the age, if we just talk about take the child molestation case out of the mix and just talk about a murder case, if the prosecutor is able to find the witnesses, the investigators, and all this, then he or she can present the same case again and avoid the error. And then in the case where the prosecutor gets the case back 15 years later and they don't have all the resources that they had at the beginning, then we're looking at something entirely different, right?
Exactly. And you'd like to hope that a case that you tried 15 years ago, or a case that was tried 15 years ago, that you still have everything, would lead to the same outcome. But once again, we're talking about 12 people, and our society has changed. Things have changed, and that's good for for bad. If you don't have everything, then that's a different question. It could possibly lead to resolving a case to a different outcome. Offering a plea that wouldn't have been offered years ago. And honestly, that's one of the positives about things changing. There are new crimes. There are new sentence options that were not available. I'm old enough to remember prosecuting, and we did not have life without parole. And once y'all gave that to us, how that shifted certain dynamics and led to outcomes that we didn't have access to. I know that's one of the you have things like that. Last year's, Austin's law I think is something that people are keen on as well with the aggravated involuntary manslaughter. So it's just, you give us additional tools like that, we can use them.
Well, when you get the case back, and we'll go back, the 15 years later, and the landscape has changed, and you choose to null pros or you choose to take a lesser plea, were you wrong 15 years before? Or are you playing by the rules? 15 years ago, you played by one set of rules, and now 15 years later, you're playing by the current set of rules.
I don't think that, I would never say wrong. I would say basically that's a decision that's made at that level, and, the person who ultimately makes that decision.
Within the rules that are there at that time, correct?
Yes.
Yeah, so, 15 years ago, this may have been this kind of crime, and because of the characteristics of the communities, the mores, the norms, 15 years later, it's a little different. So where 15 years prior, it was a felony with this sentence structure, and now 15 years later, it may be a misdemeanor of high and aggravated nature with an entirely different set of rules, right?
Yes, I
Yeah.
hope that doesn't happen, but yes,
Yeah.
You're
Well,
exactly
with
right.
the-
And that's one of the things to point out is
Yeah.
that suddenly if a crime is no longer a felony, but it's a misdemeanor, that changes what we can do. And if that was your underlying felony for a felony murder charge, suddenly that's gone. We can't prosecute that.
So was the person wronged 15 years before?
I would,
Based on those circumstances, if it comes back on my word technicality.
how I would judge it is you have to judge it at the time. You can't judge, we can make comments about, I wouldn't have done that, but ultimately, in the moment, we have to judge what we know at the time. There are instances and there are times when prosecutors don't know everything.
Did you say prosecutors don't know everything?
Oh, I'm very quick to say that. There are times when we have issues and there are things that come to light after the fact for various reasons. And, I think that it's very easy. We do that in all aspects of our lives in society to look back and say, okay, well, the decisions that were made 50 years ago, 100 years ago, how, those are so wrong. We can't believe we did something like that. At the time, though, based on the information you have, you make the best decision you can. That's why, for us, we have our ethical rules, we have our duties, and, the belief that we're, and the presumption that we're always acting in accordance with those.
And would you say, looking at the numbers as we were talking about before, overall, and you and I have worked on legislation together with our friends over at the House on prosecutorial conduct and everything else, but the vast, vast, vast majority of our prosecutors are ethical and men and women of high character that go in there to jobs that don't pay for a law degree, but go in there in public service and actually every day do the best they can.
Yes.
The vast majority.
When we have somebody who acts not in accordance with those high standards, it's a rarity, and they stick out. But the vast majority of the people who've taken the oath to be prosecutors in the state are some of the highest character people I can think of.
Yeah, and just like attorneys, the vast majority of practicing attorneys, we know all the lawyer jokes and we know what Oglethorpe's rules were when he founded Georgia, but we'd be in desperate trouble without the attorneys that we have that work in the courtrooms here in the state. As I argue, the same way we would be if we didn't have 99% of every man and woman in the state that wears a badge were good, ethical, honest men and women of high character, right?
Yes, and I can say that for every profession.
Well, I'm talking about in the criminal justice realm, where a lot of times we get a lot of attention when there are fractures in the criminal justice system. But I think the reason we get so much attention is it is the most incredible criminal justice system in the world that we have here in the United States of America, that when a fracture does appear, and it's such an anomaly, I think for the most part, that I mean, we just get attacked because it's a lot of times everybody goes, well, if this is happening, then it must be happening everywhere. And we've seen it over the past 15, 20 years. We've all heard the lawyer jokes ad nauseum. And when we hear of one prosecutor, there's all of a sudden a bright light put out there to look at every prosecutor. And if we see an ugly videotape in Memphis of law enforcement officers taking action, we assume that's standard operating procedure in every law enforcement agency in the United States, when in fact it's not. And I say all that to say, I think you and I both agree mistakes are made, but rarely are intentional actions taken in the system to deny due process to the accused or to the victims. Would you agree with that?
I would agree with that. And when those instances are uncovered, there's usually swift condemnation and mean measures taken to fix it.
And
not let it happen again.
And in some cases, overkill. Just to make an example, to crucify the prosecutor, the attorney, or the other person within the criminal justice system. And I just
I'll take issue with the word crucify, but I would say that there's a certain level of condemnation that goes with it, but it's also a violation of the public trust.
That's right.
That's when working for the AG's office when I was out at representing Post. One of the things that we used to talk to those officers about is that you're given a license from the state of Georgia, a badge, a gun, and the ability to take people's civil rights away. And so if you want to do this job, if it is a calling for you, it's a high standard. Same thing with me. In my job, I can put pencil to paper, and I can put charges upon somebody. I can take away somebody's liberty. I can take away attempt to seize their assets. It's a very awesome responsibility. It's something that you should never do joyfully. You should never do with I'm excited to go to the grand jury today and see how many people I can indict. I tell young prosecutors, if you're counting your wins and losses, stop. Because one, you're going to have, if you're in this profession long enough, you're going to have so many, the numbers are going to be meaningless. The other thing too is, that doesn't define who we are. It's, this is, when we're trying a case, we're talking about, asking the community, is this conduct that you want to allow in your community? Is this something that you think needs to be, sanctioned? It's something you should do with a certain level of humility and a certain level of respect.
Would you agree, as we start winding down, would you agree that there have been mistakes in the system where innocent people have been convicted of crimes they did not commit?
Yes.
And
we get it, like I said, we get it wrong.
Yeah. And would you,
sometimes,
in the we get it wrong, do you think the majority of those are intentional? Or do you think they're mistakes in the system?
I think there are some mistakes that are made in the system. I think on the rarest of occasions there is some intentionality. But I also believe that, once again, our emerging technology, if DNA said this person was responsible and 15, 20 years later a better DNA test is available and says they're not responsible, yes, it's a mistake that person got convicted, but at the time, we used the best we had.
Right.
And and that's why I'm not as quick to condemn that, because we did use DNA. This wasn't simply this saw defendant, arrested defendant, convicted defendant. We actually, there was a process, and our system is flawed. Our system has issues. It always can be improved. But it's also the system that everybody wants to be a part of, and people want to copy. It is the best system. And maybe I'm wrong on that part too, but I believe in that. That's why I'm part of it.
Yeah. Any committee members have any questions for Mr. Smith?
I just
Got you on 10?
Thank you, Mr. Chairman. I just wrote down 4 questions while you're doing your testimony. Is it okay if I ask, Mr. Chairman?
I wish you would.
Okay. Thank you, Mr. Chairman. What, I'll get where I can see. In Georgia, what percentage of murder cases that go to trial result in a conviction? Do you have any idea?
I have no idea. I would, and I even hate to, I'd hate to guess. I truly don't know.
Okay. Another question is, of cases that are reversed, how common is it that the case is reversed on a technicality, but the issue of guilt was proven without a doubt?
But without a doubt, it's never. You remember the standards beyond a reasonable doubt.
Without a reasonable doubt, excuse me, I'm sorry.
How many times are there technical reversals, but the evidence, usually
Let me rephrase it the other way. The evidence is overwhelming, but it was reversed on a technicality. Is that common? I mean, how common is it? I know it's not common, but...
it's not too common that if there's going to be a reversal, but didn't say there's overwhelming evidence. Usually if there's a reversal, there'll be something along the lines of there is sufficient evidence to allow a retrial. It's very rare that there's a mistake and then the court will say, and you can't retry the person. Usually if there's, and using the example again of the improperly admitted evidence, the court didn't say that the person couldn't be retried. It just, it's usually some language along the lines of that if the state wishes to prosecute again, they can.
So the individual wasn't exonerated. It was sent back and said, but there was a failure in the system and you have to go back and correct this failure if you want to retry the person, right?
And then we get into the quibble about exoneration because, was that improperly admitted evidence what led to the conviction or not? So we would have to try the case the second time to make that determination.
Right.
How common or uncommon is a new trial based on someone filing a habeas corpus?
Usually the vast majority of habeases are denied. There are some that are granted. Once again, I hate the ballpark because I've been out of that world for a while, but those are numbers that could be obtained from, or maybe not a complete picture, but a good picture. The AG's office could provide that information as to how often they see a habeas being granted.
Is there a shelf life on a habeas? Would you say that if a habeas is granted within 5 years, it has a much greater chance of retrial than a habeas that's been granted 20 years later?
It depends.
Depends on what?
It depends on what kind of case it is. Depends on what the reason for the habeas is.
And does it depend on resources available at the time of the original trial and those resources available at the time of the habeas?
It's going to depend on the quality. Yes, that's one of the things. And like, for instance, one of the things that I didn't get into, but like, where is the evidence stored? Because once a conviction is obtained, like when I go to trial, I tender my evidence. Like say it's a murder case, there's a gun involved. Well, once I introduce the gun at trial, that gun has to be kept in a secure location. Sometimes secure locations are no longer secure. Sometimes acts of God make those secure locations inaccessible. A tornado comes through and wipes out a sheriff's office. A fire burns down a court reporter's home. Suddenly, my evidence is no longer available to me. Those are real world situations.
And that habeas comes back, your evidence is burned up. What are your options?
Try to recreate the evidence as best we can and argue that, yes, this is not the gun, it's similar to the gun. But then if one of the arguments was that they want to do ballistics testing, we're now denying the defendant their ability to test that.
And so what would a reasonable prosecutor do in that circumstance?
Try to negotiate a deal or end up, or that might be one of the reasons for the no process.
Okay, and now you do
and by negotiated deal, it could be something that might be one of those. It's less than the main charge for various reasons. What can you prove?
But based on the fact that you have lost this evidence and you do a null process, is that individual exonerated?
And that's one of those things. I don't know the answer to that question.
Yeah.
Because that's, in my personal definition, your definition, somebody else's definition, it's going to be different as to what exoneration means.
Yeah.
One final question. And I know we had a case in Georgia where a DA was charged with the situation down on the coast. But
Okay.
when you have a situation where a law enforcement officer knowingly withholds evidence, or a district attorney knowingly withholds evidence, what kind of sanctions are in place as far as that person? You know, in my opinion, that would be something that is unethical, right? What kind of sanctions are in place or in the past have been done in situations like that?
For the officer or for the prosecutor?
Either one.
For the prosecutor, for the officer, they could be charged with a crime, but usually it's post that gets involved, and their license or their ability to be a peace officer would be suspended. They could be terminated from their job.
Violation of oath of office, yeah,
Or nothing can happen.
yeah.
Depends on the culture, depends on the agency. There are some very forward-thinking, very progressive agencies, and progressive in not the negative way of saying that, but
Right.
in the positive way of thinking that those professional law enforcement agencies would definitely make sure that the person is no longer part of the law enforcement community. For prosecutors, y'all created an agency that provides that oversight. The voters do have an opportunity to speak about whether or not that person should be a prosecutor every 4 years. Civil lawsuits could be filed, depending on the nature of it. It all depends on how things are done. I mean, obviously, the state bar can get involved too.
And the Attorney General's office too.
Right,
Yeah.
right.
Yeah, because the situation over in Columbus where that elected DA was prosecuted, disbarred, and removed from office upon conviction.
Yeah, it went to Jackson for a little while. And you said something about filing civil lawsuits. Can you explain what a 1983 action is?
That's a violation of civil rights. It's usually, and I could be wrong, but you file that in federal court rather than state court.
Right.
You'd file it against whoever violated someone's civil rights.
Could you file that against a prosecutor, law enforcement officer, or a circuit city?
I don't know if you can file it against the city. That I don't know.
Well, I guess city would not be.
I think you'd have to file it against people.
Yep.
And yes, you can file a lawsuit against anyone.
Yes.
Whether or not the person has defenses that
Right.
prevent them from being sued.
But there's a real possibility to Chairman Goodman's question is if, and I'm proud to say that Georgia revokes more post certifications against law enforcement officers than any other state in the United States. We don't tolerate unethical behavior. But if a law enforcement officer or a elected district attorney violates the rights of an individual, the individual does have the recourse of filing civil action under 1983 action, right?
They have the recourse whether or not, then we have to get into a lot more technical things about whether or not that lawsuit could go forward.
Right.
Because there are some immunities and other things that are
Right.
at stake there.
But they have that option if their claim is the immunity is not there because the individual acted outside of the scope of their elected office, if
Or
you will.
acted,
The
or acted
oath.
with intentional malice or
Right.
something like that, yes.
Right. Okay. All right. Robert, I appreciate it a lot. Thank you so much.
Thank you.
We're going to try to keep moving. I'd like to. I'd like to call up Maggie from the Secretary of State's office. Maggie, you're welcome to, yeah.
Good morning.
Good morning, Maggie. If you do me a favor, if you would identify yourself and your position with the Secretary of State's office.
So my name is Maggie Hasty. I'm the Deputy Chief of Staff for the Secretary of State's office. And one of the many hats that I wear is running the Claims Advisory Board, which is what kind of provides recommendations to the legislature for compensation or not. So Chairman Robertson asked me here today to just kind of walk you all through the process of what it looks like on our end. So I'm not here to talk about any of the individual claims, just to kind of go over the process. But I'm not an attorney, so hopefully it won't take as long.
Wait, you're not an attorney?
I'm not an attorney, no.
Oh, that's so refreshing.
I am going to law school in the fall, though, so.
No, I'm just kidding. Picking on Robert. But if you would, what we want is the structure and operations of the group you're in charge of, if you will, on compensation.
Yeah, absolutely. So the Claims Advisory Board was formed, I think, in the 1960s as a way for people to have claims against different state departments or agencies. And so it could be any department or agency that has had some sort of monetary impact on an individual. In more recent years, it has become a process for people to use these wrongful conviction compensation claims because there is no real statute in Georgia for people to ask for compensation for wrongful conviction.
Do you have any idea when the first wrongful conviction claim was made?
I don't, but I do believe it is a more recent, like I want to say 10, 15 years more recent. The Claims Advisory Board is made up of designees from different state departments. So it's the Secretary of State's office, the Department of Transportation, the Department of Corrections, and the Department of Human Services. It's supposed to be the heads, but they can send a designee, and typically they send their general counsels. This time was the first time that I've ever sat on the board, and that's just because our general counsel was busy because we have a very strict time constraint over when we can host these meetings. So in order for someone to have a large claim, which is anything over $5,000, it has to be submitted to the Secretary of State's office by November 15th prior to session. Once we get that completed claim, then I send a copy of it to the department that the claim is against. It has to be against a specific state agency, so they can't just say the state of Georgia generally, and it can't be against any other level of government. So I think there was one last year where they mentioned a district attorney's office, and we denied that based off of the fact that they're not a department of the state.
So what agency are these compensation claims directed at?
They have been different. So whenever I first started, they were typically all against the Department of Corrections, and it's this is obviously not a perfect system because it's not necessarily one department's fault that someone was wrongfully convicted, but the Department of Corrections can confirm the amount of time that these people were incarcerated for, so it kind of gives a little bit more information to the board. But they could also have the claim against other agencies. I know that they have had one against the Georgia Bureau of Investigations. The one from this year was against the Department of Administrative Services. And again, it's kind of an odd system.
A compensation claim against the Department of Administrative Services?
Yes.
Okay.
So I believe that it's because in years past, whenever a compensation resolution was filed, they direct the Department of Administrative Services to pay that out just for sake of ease, I think, for the state. As opposed to it going through the Department of Corrections budget or any other state agency. Department of Administrative Services is a little bit better set up for it. So after I get the completed claim, I send it to that whatever department or agency it's against. They have 45 days to get a claim or a response back to me with kind of their summation of the claim and make a recommendation for payment or non-payment. If it's a recommendation for payment, they have to give me an amount. After I've received all of that, we wait for session to begin, and then a compensation resolution has to be filed in the House of Representatives because it's a funding bill, so it has to start on the House. And I also, for the claim, the claimant has to have a representative agree to sponsor it before they can even file it. So I had someone reach out to me in the past, not about a fiction claim, different claim, but it was a large claim, and they could not find a representative to sponsor it for them, so I had to say that, sorry, your claim is not properly filed. We couldn't consider it. So they have to have someone who's willing to file a resolution for them. Then the resolution is filed in the House. Once that happens, we set a date for the meeting, and then we hear from the claimant, we hear from the representative, we hear from the department, and make our recommendation for payment or non-payment. Typically,
Real quick, you hear, at this meeting, you hear from the sponsor, the rep,
yes,
and who else do you, and the department,
the department that the claim is
in which
against,
the claim's against,
and the claimant.
and you hear from the claimant themselves. Yes, ma'am. 8.
Eight.
Yes, ma'am.
The agency has 45 days to respond to the claim with a recommendation amount, did you say?
Yes.
So when they are presenting then to the Claims Advisory Board, the only claims that you're hearing are, is it true that the only claims that you're hearing are from the agencies who say yes?
No, so we hear from whether it's a yes or a no, we consider that. And, we take as much into account as possible. I like to read news stories and look at case filings and anything that I can get my hands on to kind of color the picture, because I am the one kind of like writing up the summary to give to the board members for them to vote on whether they accept that or deny that recommendation from the staff.
How is the amount determined? Who brings that amount? Is that just in the resolution that the
So-
representative brings forth?
The claimants have to bring an amount whenever they file, and it is entirely up to them. They have different formulas for determining what that amount looks like. It's typically based off of federal statute or other surrounding states that have a compensation statute. Sometimes they adjust for inflation because a lot of state statutes are much older than.
So the claimant themselves come up with the
Yes,
number?
and it's based off of the number of days incarcerated.
Right.
Times a certain amount per day or per year.
And the Department of Corrections in these are the primary department, would you say?
I would
that
say they're the
more-
most common that the claim is against, but it's not necessarily only about the Department of Corrections. I have the ones that y'all are considering today. Department of Administrative Services, Department of Corrections, Georgia Bureau of Investigations, and the Floyd County Police Department, which we did not recommend for the Floyd County because it's a
Yeah,
different level of government.
so the Floyd County Police Department would not be a proper,
Correct.
right, because they're not a state agency, is that correct? Okay, all right. And so when they bring these to you and they bring the amount, then you do a summary through research. And do you have help, or are you there?
No, I'm doing this at the beginning of session, so it's kind of an odd time for me, but it's like when everybody's calm at the beginning of session, I'm like fervorously researching.
And that information you take in front of, now you're the SOS representative on there, so it's you, a representative from the Department of Transportation, a representative from the Department of Corrections,
Yes.
and a representative from Department of Human Services.
Yes.
Okay. And then you present the
So
the
I write,
resolution?
yeah, I write my own summary. I send them all of the filings that I have, a copy of the resolution, and then my own summary that I've created with my own recommendation for payment or non-payment. And then the board votes to either accept that or deny that recommendation. And this whole process, it's just a recommendation to the legislature. The legislature is not required to accept our recommendation or deny our recommendation. It's just kind of supposed to be guidance for the legislature.
And so if you recommend non-payment, that does not stop the resolution from moving forward, correct?
Correct. So the recommendation for non-payment is based solely on the lack of culpability of the State Department or agency. Again, this is really not a perfect process for wrongful conviction compensation because obviously it's not the Department of Corrections' fault that someone was convicted incorrectly. So we can't, with legally or in good faith, say that it was a specific State Department or agency's responsibility for this person to be wrongfully convicted. Now, there is one exception. There was one recommendation for non-payment or for payment last year, and it's always been the position of the board to not actually recommend a specific amount. So I believe that the recommendation for payment was for Joseph Samuel Watkins.
And that was against the GBI?
Yes, and that was based off of testimony from the GBI. So that is why there was a recommendation for payment, is because the board saw some amount of responsibility on the department's behalf.
And did the GBI oppose the compensation? Or was there not, was it just blanket testimony? There was no,
Yeah, I think they gave their recommendation, and I don't believe it was for payment, but
okay.
I don't think that they were entirely opposed. I do think that they recognized that there was some culpability.
Okay. And you say this is not a perfect system,
Mm-hmm.
but it's all we have right now, right?
Correct.
Okay. And so is there ever an attempt to bring in the prosecutor's office where the case was originally prosecuted, or?
I have not brought in the prosecutor or brought in any other level of government.
And I don't
beyond-
mean to necessarily
No,
oppose it,
no.
I mean just to offer facts up.
I would certainly be open to that, but currently it's a very short time frame, and asking someone from the prosecutor's office to show up for a case that was tried 20 years ago is kind of a.
And these cases are typically old cases?
Yeah, I think the majority of them are, well, they're not old, like they were originally tried.
Not like my age, but yeah.
They were originally tried 20 years ago, and then they had a petition for habeas corpus within the past, generally 2 years of filing.
Okay. And how long have you been doing this?
This is my 4th session doing it.
Okay. And so between November 15th, I think you said?
Mm-hmm.
And is that when the cases are typically brought to you, or are they brought throughout the year?
They're typically brought to me on November 15th.
Okay, so you have from November 15th until
Mid-January.
mid-January to research the facts of the case, bring the board together. And does the board meet on a schedule, or do you have to call the board
No,
together?
I have to call the board meeting.
So you call the board meeting, and then you present the claim.
Mm-hmm.
And when you present these claims, do you present these claims all together? I'm saying, like you have a list of multiple claims?
Yeah, so I think the most we've seen in 1 year is 4 claims, and we hear them each individually.
Okay, are there other claims, I know, say, against other departments that have nothing to do with wrongful incarceration?
There are other claims that come through the Claims Advisory Board, but they're typically under the $5,000 threshold, which is
Okay.
why you guys never see them. Is they don't have to go through the whole resolution process.
But do you have others that are above the $5,000 threshold? Say if there's a claim against Department of Transportation related to an accident or something like that, or?
No, I had one person who attempted to file a large claim, but they weren't unable to find someone to agree to sponsor their resolution.
Unable to find a representative in the House?
They were out of state, so they didn't have a local representative.
All right. So the vast majority of these claims are wrongful incarceration claims?
Yes.
Okay. And so you get the claim, and there has to be a resolution to go with the presentation?
Yes.
So these resolutions are filed prior to November 15th?
They're filed at the beginning of session.
Okay.
So I have the
You
copy
have
of
something from a representative that said, when session starts, it's my intent to file a claim.
Yes, they
on
have to
this-
sign
on this-
the
A resolution
claim.
on this individual's behalf.
Yes.
Okay. And then between the 15th and middle of January, you get the meeting together, present all of these claims. do you normally present the claims and then there's a wait period while the members of the board digest the claims, or is it
I
you
send them all the
present claims
materials in
and-
advance and they do
Okay.
their own research. They're all attorneys, so
Right.
they love to do their own research.
Okay. Any questions, Senator Goodman? Nothing? Okay. And I can't imagine the responsibility and the pressure coming in there. But anything else you want to offer on the claims process?
No, I think I just would want to say that this is not a perfect process and that the recommendation from the Claims Advisory Board is not something that the General Assembly is beholden to. Certainly, this process is not meant for wrongful conviction. It is meant for people who have monetary claims against state agencies. So I would ask that you consider them within the full picture, not just be beholden to the Claims Advisory Board
Right,
recommendation.
and I think there are several of us that agree with you that this is not I wouldn't say not the perfect system, but just not the right system, and that we need to sit down and put something together that we think would fit better into this process. That in my perfect world would take the legislators out of the process as much as possible. But are you aware of any other state that handles these types of claims the same way the state of Georgia does?
Not the same way that the state of Georgia does. I know that there are other states that have wrongful conviction processes and,
Right.
you know. I
But
think
they don't involve the Secretary of State's office, 4 attorneys from
state
8
agencies.
state agencies and then one individual in the SOS office that's tasked with doing all the legwork on investigating and presenting these claims before those attorneys, right?
I'm not familiar if someone had a similar system.
Okay.
So,
Well, Maggie, I want to thank you very much for
Absolutely.
your testimony this morning. I
Yeah.
appreciate you.
Happy to be here.
Bring light to the darkness.
yeah, thank you.
Thank you. Having heard our first 2 witnesses, and there's a sign-up sheet, I haven't had a chance to check it. Would you grab that sign-up sheet for me? Joe Cook from Floyd County. Is Joe Cook here? Is that right, Cook?
That's correct, yes.
That is Cook. Mr. Cook, if you want to have a seat. Hope you're doing well this morning.
I am. Thank you for allowing me to speak before you.
Yes, sir.
I know it's been a long hearing already. I'll try not to take too much of your time. but-
Listen, we have to be out of this room by 11:30, so I think we're going to be okay. Senator Brass is going to be setting up for a very large rules meeting today. I just think it's important we have that we have a legitimate conversation about the process and about the compensation resolutions that I think we've lacked in years past, and I think this is a good start to that, and so I appreciate you. Mr. Cook, I don't know what your testimony is about, but I look forward to hearing it, so the mic is yours.
Well, I think over the past 2 hours of testimony, I think one thing that we have determined is that a new process is needed. And I think the legislators that are sitting behind me have a solution in House Bill 533, and it would be great if we could move that forward. I first want to thank Representative Katie Dempsey for her efforts on behalf of the wrongfully convicted that are on this resolution that you are considering. She's a neighbor and friend, and she is a tireless public servant, and we appreciate her work. But I'm here to provide some information to you about the cases of Lee Clark and Joey Watkins, who are also my neighbors in Floyd County and who I've gotten to know. Each was wrongfully convicted, and each served more than 20 years in state prison. I have specific comments about their cases, but general comments apply to all 5 of those who were wrongfully convicted. I want you to notice the words that I'm using, wrongfully convicted. Chairman Robertson, the last time I talked to you, you wanted me to define exonerated, and we've had discussions about that this morning. The question you seem to be asking is, does exonerated mean that these men that are wrongfully convicted are truly innocent? The implication was that these men who had not been proven innocent should not receive compensation. That getting off on a technicality did not equal innocence. And you're absolutely right. Getting off on a technicality does not mean that you're innocent necessarily. But that's not how our legal system works. The defendant in a criminal trial does not win acquittal by proving that he's innocent. He wins acquittal because the prosecution failed to prove beyond the shadow of reasonable doubt that the accused is guilty. So when it comes to these compensation cases, it matters not a whit. It matters not a bit whether they are guilty or innocent. What matters is whether their constitutional rights were violated. So our Georgia Constitution guarantees us, if we are convicted of a crime, a fair trial. Paragraphs 11 through 18, the very first part of our Constitution, outline those rights. If during the course of our trial, any of those constitutional guarantees are undermined by investigators, by prosecuting attorneys, by the jury themselves, then the defendant's constitutional rights have been violated. In each case before you, Georgia courts have acknowledged that mistakes were made, and those courts overturned those convictions. They were wrongfully convicted, and they lost years of their lives in prison, unable to attend school, unable to learn a trade, provide for themselves, or provide for their families. They were deprived of the liberties that you and I enjoy for 20 years. The cases of Lee and Joey are unique in that they won their freedom as a result of independent investigations conducted by undisclosed and proof podcasts. Now, I don't know if y'all have listened to those podcasts, but if you had, you would have come to the same conclusion that I and millions of others who have listened to them came to, which is that Joey and Lee were innocent of the crimes that they were accused of. These podcasters, and I've gotten to know them through their appearances at the Rome International Film Festival. A lot of people dismiss podcasters as these tin hats that are broadcasting from the basement of their parents' house. I'm a journalist, I'm a trained journalist, and I will tell you that the work that these journalists have done, these audio journalists have done, is among the best investigative journalism that I've witnessed. It's excellent work. It's professional work. And because of their work, the district attorney in Rome agreed not to retry Lee Clark's case. They said that in court. They dismissed charges. In the case of Joey Watkins, a Floyd County court granted him his freedom. So if you listen to these podcasts, you will come.
Real quick, you say the court granted him his freedom. Was
Yes.
it? Did the district attorney? Did they seek to re-indict on that case?
The district attorney did not seek to re-indict on either case.
Okay, so did the district attorney in both those cases choose a null pros? Choose not to prosecute in both those cases?
I believe in Joey's case, the decision was made by the court. In Lee's case, the decision was made by the district attorney not to retry.
Okay, and I'm just trying to be clear on both of them. So, was there an intent by the prosecutor to re-prosecute the case, and the judge took action
There-
against that?
No, there was, the district attorney decided not to retry the case.
On both cases?
On on Lee Clark's case, yes. On Joey Watkins' case, the decision was made by the court.
Do you know what decision was made by the court? I mean, did the court prohibit the?
I cannot speak to that, but
Yeah.
there are attorneys in this room that can answer that question.
Yeah, I mean, you just brought it up, so I was just trying to point of clarification. Yeah,
Okay.
I appreciate that.
Anyway, they were not retried.
Right.
Their convictions were overturned.
Okay.
But again, the point is, it doesn't matter whether they were innocent or guilty. What matters is that their constitutional rights were violated because they did not receive a fair trial. And they spent 20 years in prison. Okay?
Well, no, I mean, and I appreciate it, and, you know, you seem a little confrontational, and I respect that. So you make claims of fact, and I appreciate it. How were their constitutional rights violated?
In the case of Lee Clark, the investigative officers coerced testimony. They threatened to take a woman's children away from her if she did not testify the way that they wanted her to.
Right.
There was also testimony from a deaf man who had very limited communication skills, and that testimony was key to placing Lee Clark at the scene of the crime. But because of the work of the podcasters, it was determined that what this deaf, basically illiterate man was trying to explain to the police officers was something that had happened in a different incident. So Lee Clark was not.
He miscommunicated, so they brought in an expert later who was able to clarify exactly what he was trying to say.
Yes,
correct?
because it was very difficult to understand his way of communication, and it
Right.
took a specialist.
Right.
So Lee Clark, because of that, that new evidence that was uncovered by the podcasters, that's how he won his freedom.
Okay.
So let me just finish with this. The resolutions before you amount to $7.4 million, which is about $50,000 to $70,000 for each year that they were imprisoned wrongfully. That sounds like a lot, but I want to put that in perspective. Y'all just adopted a $40 billion budget. But
Let's be clear, not yet.
well,
Yeah, 37 billion, and yeah, we're still back and forth with that.
so
But I get your point.
So $7.4 million is 1/1000th of a percentage point of that budget. Let's just look at the rainy day fund that we have that's burning a hole in our pocket. That's $6 billion. $7.4 million is 1/100th of a percentage point of that. Okay? Let me put it in a different way. $20 right here, okay? 1/100th of a percentage point of this $20, you know how much that is? It's 3 cents. So my question is, if your neighbor comes to you seeking compensation and you know that you have violated his liberty, you have violated his constitutional rights, are you willing to give these men 3 cents out of this $20 bill to right a wrong? Are you willing to do that? I mean, that's 3 cents. My mother would tell me, if I was saying to a man that came up to me that I had wronged and he wanted 3 cents out of my $20, and I said, no, I'm not going to give that to you, you know what she'd say to me? She'd say, shame. Shame on you. Shame on all of us. Because you and I are the state here. We have the power to give these men the compensation they deserve. And if we can't give them 3 cents out of $20, that looks bad on you and me, because we are the state. We're the ones that put them in prison. And we need to do the right thing. So those are my comments.
Thank you, Mr. Cook. I appreciate you. It is good to see you again. Steve Cox from Floyd County. Thank you. Please don't call me that. I appreciate it, Mr. Cox. Yes, Mr. Cox. Have a seat there at mic two. Please identify yourself.
My name is Charles Stephen Cox.
Okay.
I go by Steve. I was a career prosecutor. I started out as an assistant district attorney in December 1972, I believe. No, yeah, 82. I'm sorry, December 1982, and I retired somewhere around 2016. I can't swear to the date. It's before COVID came in on us. I decided it was time to turn it over to the younger folks.
I made that decision a few years ago myself.
And I was a career prosecutor, and I enjoyed it very much.
It's a great career.
Yes,
Appreciate what you did.
Thank you.
Appreciate your
Thank you.
service. So, Mr. Cox, what would you like to talk about today?
I was the trial attorney on the Lee Clark and Kane Story case. I don't remember any other attorney in the office helping on the case other than just marginally. May have been an intern at the desk while there, but I'm the trial attorney on the case, plus the investigators. And I have learned, and I can't remember precisely when, I'm 75, so I don't remember as well as I used to.
Now, I want to be clear, Mr. Cox, you were the defense attorney, or you
No.
were the ADA on the case?
I was the ADA.
Okay.
I'm sorry, I didn't.
No, I want to make sure I didn't miss that. Thank
Before
you.
I went straight, I was a defense attorney for a while, mainly appointed cases.
Yeah.
But, no, I was the assistant DA. I'm trying to think the best way to put this. Obviously, we don't have a diagnostic machine like mechanics have to hook up to somebody that said you were guilty or you were not guilty. I was always taught, either as a defense attorney or prosecutor, it doesn't matter what we believe, it's what that fact finder believes. So I cannot sit here positively and say that Lee Clark was not guilty, but I can say that I had a concern during the trial of the case, and my experience was no matter how talented you are, most cases as you get into them, maybe it's like a football game or something, they either start getting better or they start getting worse. And it seemed like his case just kept getting worse the more I got into it. But I proceeded in good faith. I had no idea there was any coerced testimony in that. And I've been thinking, since I was asked to come down here, when did I first hear that? I can't swear that maybe I didn't see something in a newspaper article, but it was basically as a part of this podcast. And Joe Cook talked with me about it. Joe is a family friend, longtime friend. He reviewed it with me. I have not listened to the podcast. I may have listened to a minute or two of it, but it saved me time, and him saved me time. He or his wife, they prepared kind of a synopsis of it, focusing on the part I was involved in. That was the coerced testimony.
Was that from the female with the child? The testimony?
Yes.
Okay.
I don't even remember her from the case. I'm sure she was involved in it. Some
Yes.
parts of that case, we're talking, it was 1997, I think, so that's a long time for me. But some parts of it I remember very crystal clear, other parts I don't. But there was, no one said anything to me, particularly the investigators, that any testimony was coerced. I tried very hard over the years I was involved as a prosecutor to establish a standard for fairness. And without sounding too presumptuous, I felt like I did, because I wouldn't have lasted as long as I did. So if I had known that, I certainly would have reported it. But I did not hear about that except in connection, I guess, with the podcast or maybe something in a newspaper, but it was all way toward the end there. I remember working one investigator, Dallas Battle, who's now deceased. I considered him, he was a longtime Florida County Police detective. I considered him a friend. I worked with him on a lot of cases, and he's the one that evidently, along with somebody named David Stewart, who I also knew, I thought more Battle than I did David Stewart, but still, I had no reason to think these two individuals would do something that heinous, because it's embarrassing to me. I just hope people will believe that I did not intentionally put forth testimony that was coerced. The lady never mentioned it to me, and I believe from the podcast she volunteered it maybe to the ones that did the podcast. But back to I'm sorry I got off point a little bit. I cannot swear that Lee Clark is not guilty, but I can state, and you've heard in here, that the standard of doubt is somebody proven guilty beyond a reasonable doubt. I had more and more concern as the trial progressed that we had not proven him guilty beyond reasonable doubt, or the other boy. In fact, I want to say that Dallas Battle to me at some point said, it's not looking too good, is it? And I agreed. But I felt like I had a responsibility to proceed. It was a case that was true billed by the grand jury. I don't remember doing it, but normally I would open a file. Our Brady compliance is here. Here's the file. I have no reason to doubt we did not open that file to them. When the case was appealed to the Georgia Supreme Court, they had different appellate counsel, but I fully expected we'd get reversed. It was the police just kind of muffled the case, to tell you the truth. Sure enough, the Supreme Court affirmed the conviction, including finding that, the verdict was not contrary to the evidence. So I thought, well, what more can I do, We've opened the file, we've complied with discovery, they've, they had hired attorneys, they had good attorneys at the trial level, they had good attorneys at the appellate level, but I just wanted to let the court know that I cannot sit here and say he absolutely was not guilty, but I had serious concerns that we had proved it, and I had that concern after the case was over, and all these intervening years I've had that concern.
So you can't say that he's not guilty, but legitimate concerns arose during the trial, and was there ever any consideration to withdraw the charges during the trial?
No, because we had a young man who was dead, about the same age as those others, and again, we had a case that was true billed. If I had known that was coerced testimony, I might would have done something like that. I would have gotten with Miss Patterson, the DA, but it was just one of those. You try so many cases as a prosecutor, you don't get to cherry pick.
That's right.
You try so many cases, you kind of take them as they come. You do the best you can. You try to be fair. But we didn't get to the point where I'm dealing with perjured or coerced testimony. I had no reason to feel otherwise.
Has there ever been any evidence other than the evidence that was brought up during the podcast? And full disclosure, I've never listened to the podcasts. I've found many times that where you would find a documentary on Netflix talking about an erroneous conviction. Within a year, there would be an opposite side given. And of course, we're running through that right now with the Menendez brothers and everything else. And I tell everybody the cop shows that I watch that truly depict the career I did are Dragnet, Adam 12, and Barney Miller. And nothing has ever been produced since then that actually shows the true occupation that I participated in. So was there ever a time between the conviction and the podcast where you were made aware that this lady made the claim that her testimony was coerced?
Not that I'm aware. She
Okay.
certainly didn't make it. Again, I don't remember her. I can't say I never talked with her, but I think that would have stood out in my mind. And I often wonder, well, the judge on the motion for new trial or whatever, evidently it was Judge Niedrak, I believe. He's a fine judge, fine gentleman. And I'm satisfied in my mind that he was satisfied that she was telling the truth when she said it had been coerced. So I'm not trying to
Right.
revisit all that.
Right.
I just wanted to let this panel know, again, that I had some serious concerns, but because of the circumstances I have mentioned, I felt like it's my responsibility to go forward.
In what year did you retire?
Somewhere around 2016 or so.
Okay.
It was before COVID.
I remember years ago there was a case out of Savannah, Troy Anthony Davis, where he was convicted of murdering police officer Mark Allen McPhail.
Mm-hmm.
And toward the end of his appeals, his new attorneys brought forth recantations of witnesses, where witnesses came forth and said that they wanted to take back things they had said years past. And I think the federal judge in that case said that the concern he had was that you can't walk around with recantations in your pocket as an attorney and then play them as if you're playing cards
Right.
when the time is right.
Right.
So that was the reason for my question about, do you know if there was any time between the end of the trial and the habeas hearing that came back, if there had ever been any evidence, or excuse me, the podcast, if you will, that there was never any evidence of this lady, and I think you said her name was Patterson, where she, I guess, even more so than recantation, it was coerced
Yeah.
testimony.
Not that I'm aware of.
Right.
And
Okay.
the point I was going to make, we have to try our cases as we find them.
Yes, sir.
They're usually under-investigated, need a lot of work, and if you only try the perfect case or the case that's going to be easy, you're not doing your job. So that's why I went forward with that. It didn't sound like the best case in the world, and the more we got into it, the worse it got. But I thought, well, I've got to write it out,
Yeah. You want the perfect case, but if you go
And
looking for the
found it.
perfect case, you're not going to find it. That's
In
right.
30-something years, never found it.
Yeah. Well, Mr. Cox, I appreciate your testimony. I appreciate your time. Any questions from the committee? You were on 10?
Yes, sir. Yes, sir, Mr. Chairman. Without Ms. Patterson's testimony, is there any way in the world you'd ever got a conviction?
That's a tough one. You're not referring to the DA, Mrs. Patterson. You're talking about the recanting witness, correct? And again, I'm embarrassed to admit I don't remember her testimony, but I know she gave it, or somebody would have questioned that. Probably not. There was one witness that worried me, the young man that, I hate to use the word deaf and dumb, but was challenged. He came across as, he's the one that saw the Darrell Clark running around the trailer, And I had a real tough time with him. In fact, Judge Walther was an incredibly fair and good judge. Judge Walther gave me more leeway with him than I thought he would. I was saying, Mr. Clark, do you see the person in the courtroom that ran by the trailer? He just looked and looked, and finally, Judge, I was desperate by then. Judge Walther allowed me to stand kind of right behind him at the defense chair, and he pointed out. I was concerned about that part, too. I felt like that was very flimsy evidence, and that's probably the strongest evidence against Darrell Clark as there was, but without.
Was the mentally challenged or the gentleman that couldn't hear and couldn't speak, that would, you said, would be the strongest evidence you thought at the time? Or the
Probably.
identification in the courtroom?
Well, the identification in the courtroom was real tenuous.
Yeah.
But that was the main evidence, other than I think we had him. I'm trying to think if anybody put Mr. Clark back in that bedroom or not. That they were in a little trailer, and the boys went back to that room, and I don't recall if Darrell Clark was seen going back in the room or not, but he was seen running.
And remind me, is this the case where the gentlemen were claimed to be playing Russian roulette?
I think so.
Is that right?
Again,
Okay.
I'm sorry, I have not reviewed the trial transcript and all. When I did the appeal to the Supreme Court, of course, I was very familiar with it, but I haven't reviewed it since then.
Okay. Well, again, Mr. Cox, I appreciate you, appreciate your testimony, and appreciate you coming out here today and sharing with us. It's obvious you care dearly about your profession.
I do.
And that comes across, and I greatly appreciate you
Thank you,
today.
thank you for listening to me.
Yes,
May I
sir.
be excused at this point?
Yes, sir.
Do
Yes,
I?
sir. No, sir, you can go forth and share your kindness with the world. We appreciate you coming in. Thank you.
Thank you for listening.
All right. Mr. Sam Dawkins. Mr. Dawkins, you sit there, right there. Yes, sir, please. Yeah. And if you would identify yourself and,
Thank you for having me.
yes, sir.
My name is Sam Dawkins. I'm retired from Georgia Power Company with a little over a 40-year service. I'm here today to testify about the murder of my son Isaac. On January the 11th in the year 2000, my son Isaac was leaving Floyd College and was driving down the highway when a car was seen speeding after him with muzzle flashes coming from the car. He was struck in the back of the head and subsequently died from his injuries. 2 people were arrested for his murder. One was Joey Watkins, and the other one was Mark Free. Joey Watkins was tried and found guilty, and Mark Free was found innocent and released. Now, all this stemmed from some bad blood between them over a girl named Breanne Scarborough. My son had dated his ex-girlfriend, and I think
Who's ex-girlfriend?
Joey's ex-girlfriend. My son had dated her, and Joey had made the comment to several people that he was going to get Isaac. And he eventually did. And over the years, I have attended every one of his habeas meetings, all of his appeal processes. I've been to every single one of them. Even when COVID struck, I was able to attend them through Zoom meetings and things like that. Well, over this period of time, I was approached by several different entertainment companies, such as Dateline, 48 Hours. I think this Discovery ID even contacted me. I think this Undisclosed Podcast even contacted me one time. I don't know how they ever got my phone number, but they did. And they wanted me to tell my side of the story. And to each of them, my answer was the same. I didn't consider my son's murder for their entertainment purposes. And so it went on like that, just attending the appeals and all. And eventually, I think, and I'm not sure how they got the information, but the Georgia Innocence Project went around and I think they interviewed some of the jurors that were on the case that convicted Watkins. And one of the jurors indicated that she had indeed driven the course of the road that was there was a question of the timeline. But anyway, she disclosed that she had driven it herself and that it was possible. And I think when they asked her about it, she said, well, she did it during jury recess. I do remember that the judge sent the jury home on a Saturday night. It was really late. And he said, tomorrow's Sunday. I want you to all take off and come back in here Monday morning, and we want a verdict. So apparently this woman drove the route that was in question. And she came back, and I think she made the statement that the timeline was indeed possible because she drove it herself. And
She made this statement to the other jurors?
I believe so.
Okay.
I believe so. And I think that the Georgia Innocence Project, armed with this information, was able to secure Joey Watkins a new trial based on that and that alone, jury misconduct. There was no new exculpatory evidence that claimed him to be innocent. And the Rome News and all was talking about Mrs. Dempsey trying to get compensation for Watkins and some other guy. I have no clue as to his case or whatever. But that's when I started reading about it and saw that you were involved with it, and I reached out to you to tell you the truth about what happened. Since then, I have...
Well, just to be clear, you reached out to Chairman Tillery first, and he connected you and me.
Chairman Tillery, Randy
Yes.
Robertson, and...
Just a whole motley crew.
I have tried to contact Katie Dempsey over this. She never returned my phone calls, any of my emails. Bill Shiflett, retired chief of police, has tried to contact her. As far as I know, she's never returned any of his calls or emails.
Let's go back to the juror misconduct is what you were told.
Yes,
was the reason.
I went to the Georgia Supreme Court hearing on it, and they ruled 9-0 in favor of juror misconduct.
Yes, sir.
Because his rights were violated, and I can understand that, you know. But he was released on a new trial.
Yes, sir.
And there was no exculpatory evidence, regardless of what the Georgia Innocence Project says, that released him. And to keep saying that he was exonerated, I even sent emails to the Rome News Tribune to please stop saying that he was exonerated. And it's just been a nightmare that never ends. Try to imagine that your child is murdered, and then now you've got people trying to give him $1.8 million. It's just insane. I can't believe it's happening. But before all this, I'd like to say,
go ahead, yes, sir.
Before all of these entertainment companies got a hold of this story, I was in Lowe's in Rome, Georgia in 2010. And I was leaving out through the garden center, and I ran into one of his attorneys at the trial. His name's Bill Odell.
Mr. Watkins' attorney?
Mr. Watkins'
Okay.
attorney at the trial. His name's Bill Odell. And I recognized him right off. This is after all his appeals and all had been exhausted, before the Georgia Innocence Project ever got a hold of this. And I said, "Do you know who I am?" And Mr. Odell said, "Yes, sir, I do." He said, "You're Mr. Dawkins." And I said, "That's correct." And he said, "I want to tell you just how sorry I am that you lost your son." I said, "Well, thank you, Mr. Odell. I appreciate that." And he proceeded to tell me that one of his children had died too, and he knows what it's like to lose a child. And I said, well, I appreciate that. And after a few more words, I turned to leave. And as I was walking away from Mr. Odell, he made the comment, oh, by the way, you didn't get the trigger man. And I stopped dead in my tracks and turned around, and I said, what did you say? He said, you didn't get the trigger man. Joey was driving the car. Mark Free's the one that actually pulled the trigger. And I think then I proceeded to call him a SOB and told him, what a piece of crap he was. And he said, you have to understand, Mr. Dawkins, I'm just doing my job. And I said, calling it your job doesn't make it right. You knowing he was guilty the whole time. And he said, well, and it started to get heated, and people were starting to notice, and I turned and left before it got worse. And so try to imagine that his own attorney has admitted to it, and now you've got people trying to compensate him for it. It's about more than a father can stand. And I'd like to say to the gentleman, if he's still in this room, that testified up here earlier, that said that it doesn't matter if they're guilty or not, if their rights have been violated. I'd like to say, wait till somebody puts a bullet in his child's head, and then somebody tries to make them rich off of it.
Mr. Dawkins, I know you don't mean that as a threat. I know you
I don't
just
mean that as a threat.
I appreciate that.
He just
Yes, sir.
has no idea of the pain and the heartache. It's something that you get up and you live with every single day of the week.
Yeah, Mr. Dawkins, we committee members, all of us have sons and daughters, and I'd love to tell you I feel your pain, but I don't, because my son's healthy and nobody. And you and I had a brief conversation one day, and you mentioned this, and I told you that you did not lose your son. Somebody took your son from you, and I want to be very clear about that. And we have a court system, as we discussed earlier with Mr. Smith and everything, that is not perfect. And that there are mistakes made, and rarely are those mistakes intentional. Many times those mistakes are technicalities, as Senator Goodman was speaking of earlier, and unintentional missteps throughout the system. Do you believe that Joey Watkins and Mark Free murdered your son?
Absolutely, 100%. You can talk to retired Chief of Police Bill Shiflett. You can talk to Tammy Colston. Lee Patterson is the current Floyd County District Attorney, and she'll tell you. Now, there was another thing said that said the court dismissed it. Lee Patterson's the one that dismissed the case. There's a Latin term for it, and I don't know how to pronounce it. And if you'll bear with me just a second. It's called no prosecuy.
Yes, it's called nolle pros, which means
I don't know
the
what
district attorney chooses not to prosecute the case.
Okay.
And many times that has happened. It happens, and there are people in this room much more educated than I am when it comes to law. But what it means is they don't feel they have enough evidence to prosecute the case.
Yeah.
Nolle pros does not mean that the case cannot come back.
Yeah.
It's just saying at that particular time, the prosecutor has chosen to not prosecute the case.
And that's the problem.
Yes, sir.
Because the lead investigator on the case has died. The main witness to the shooting has died. There's witnesses and people that passed away. It's been 25 years. Nobody can remember anything. He, in all likelihood, will never get brought to trial again. But it's still an open case. And Lee has been just upfront and honest and said that we couldn't get a conviction on him right now. So she has no other choice but to file So,
And you're saying that the connection between Joey Watkins and your son is a mutual girlfriend?
was a girl that is Watkins' ex-girlfriend, my son started dating. And I think that he even made a statement to some other person too, that they'll end up like Isaac Dawkins. So I think I was told that Joey's father even made the statement to my son that he buys and sells people like him every day. He's a used car salesman. Now, how would you like it if somebody told your child that? It would just,
Mr. Dawkins, I'm wired a little different than most people, I'm afraid. But listen, I greatly appreciate your testimony this morning.
I'm
And
sorry if I'm a little, seem a little upset or emotional, but there might be some innocent people in prison that deserve to be compensated. But rest assured, my son Isaac's blood is on Joey Watkins and Mark Free's hands.
thank you, Chairman Goodman. Did you have a question?
Well, first
Or a
off,
comment?
yes, sir, I'm so sorry about what happened to Isaac. And I don't know if you're the person I need to ask this question, but from my own knowledge, was there ever a gun that was discovered or any murder weapon?
No, there wasn't. They never found a murder weapon. It was known that they went fishing at a lake the next day, and it's presumed, and I say presumed, can't be proven, that the murder weapon was probably disposed in a lake, probably Lake Wise.
Has one final question, Mr.
Yeah,
Chairman? if
you
don't
asked.
mind?
Yeah, just,
Had anyone else ever threatened Isaac besides,
Not that I'm aware of. Not that I'm aware of.
and I think Chairman brings up reasonable question. What makes you believe that this man murdered your son?
Well, it was probably in October. Like I said, I knew there was some bad blood between them. Isaac had a hunting dog, and he kept it in a kennel behind our house. Well, when my wife and I had gone on a trip out of town, come back, and somebody had gone to the kennel and shot his dog right between the eyes. He found his hunting dog dead, and I was asking Isaac who he thought did it, and he told me that he thought it might have been Joey.
Well,
And-
you said earlier there was a witness that had passed away.
Yeah, the gentleman that saw the cars driving, speeding down the road, he saw the muzzle flashes coming from the car that was chasing my son. And he has since passed away.
Did he offer testimony that led to the conviction of Mr. Watkins?
Yes. But they had, the thing that, getting back to the dog issue, there was a high school football game that night. And one of my friends said that he had talked to Isaac. He was a man. He worked for him. He was a pulpwooder. Had made the comment, he said, "Sammy," he said, "did you call the police about Isaac's dog?" And I said, "No." He said, "Isaac said he'd handle it." And he said, "My daddy told me that if a man would shoot a man's dog, he'll shoot him." And those words have haunted me for 25 years, that I didn't do anything about it then. Every time I think about it, I think that I should have done something then as a father, that I failed him. But there's nothing I can do now. I can't turn back the hands of time
Mr. Watkins, were you ever interviewed or spoken to by the Georgia Innocence Project?
No, never was.
Were you ever reached out to and contacted by the Secretary of State's office to give testimony at a compensation hearing?
Never.
Is this the only time that you've had an opportunity to speak to anyone in the Georgia General Assembly concerning the potential compensation of Mr. Watkins?
In person, yes. I've sent emails to some of the senators and congressmen and women.
Okay.
But this is the first time I've been able to speak in person to anybody, so.
Okay. Well, I do appreciate that. Anything else? Ms. Dawkins, if you'll have a seat back, we'll,
Thank you.
thank you. Those are all the witnesses I have signed up. For the sake of time, I'd like to ask Madam Representative if you want to step up, and whichever one you want to do. If you want to discuss, you and I had a brief conversation about the pending legislation, and I know y'all have worked on it together. And if y'all want to have a conversation and walk through that piece of legislation together, I'm happy to do that. If y'all would like to do it this morning, I know where we are at in the legislative process. And I think I've been open with you. I would love an opportunity for us to try to come up with some mechanism within the state of Georgia that is better than what we have now. I can't thank the Secretary of State's office for their open discussion this morning enough on how this process is not the best process to get to where I think we all want to get to, or if you would rather move on into the compensation resolutions, we can do that too, whichever you're more comfortable with.
I think it would be good to go ahead, since we've all been here since 6. and
Yes,
deal
ma'am.
with the compensation resolution.
Yes, ma'am.
And then I would love the opportunity to come back after that. and
Yes, ma'am.
For us to discuss the option that the House had. But I would ask one other thing.
Yes, ma'am.
Could we take a 5-minute?
We can take a
break?
5-minute break,
We've been here.
absolutely.
I think
Yeah.
it might help everybody listen better.
Okay.
Might help me speak better.
Well,
I'll be right back.
yes, ma'am. Thank you, Representative Dempsey. Nah, brother, you know what? If you get me a fresh cup of coffee, I'd greatly appreciate that. So I can get Representative Dempsey over to rules so she can ask for some of my bills. I think y'all have rules at 9 this morning, right? Okay. And I want to thank Robert Smith with the PAC office. Robert went and checked, and 5% of habeases that are asked for, or excuse me, of all the habeas that are asked for, 5% are granted. Our next question is, we're going to try to drill down and see how many of those 5% are actually retried. And so I think those are just good numbers to have. But we're going to change gears dramatically and move over to the compensation. It'd be HR 128 in your files. And my understanding, Representative Dempsey, and please correct me if I'm wrong, that these 5 were all put into a single resolution, but you're only going to speak to the ones that you brought forth. Is that correct?
I'm going to speak to the entire kind of beginning of it and speak to the 2 resolutions that I have within it, and then the others will come up. And
Okay,
each
who
of
are
us-
who are your 2?
So my 2 are the first 2, Part 1 and Point 2.
Okay, Watkins and Clark.
Watkins and Clark, that's
Yes,
right,
ma'am.
from Floyd County.
All right, ma'am, the floor is yours.
Yeah, well, thank you. Well, thank y'all for being here. I appreciate it. Senator Goodman and Robertson, y'all have hung in here the whole time. I appreciate that. But to your whole entire committee, I know this is hard to get up at this point in session and to be here. And you do have things pending and rules that probably won't get out today since we can't get down there. But, I will tell you, this is such a serious subject. And I have taken it seriously. It was not something I sought. It was something that came to me in a very responsible way. I have not seen the podcast either. I want to make that clear. I'm not into the entertainment or any kind of joy part of this. I think that a wrongful conviction is unimaginable. I often put myself in those shoes. And I think, because it could happen to any of us, or our children, or someone we love or care about. These mistakes do happen. I wouldn't last 10 minutes in prison, and y'all know that. I would need a lot more than money to make me whole. And when you are found to be innocent, you walk out with the greatest gift of all, your freedom, but a pat on the back. It's not like the wraparound services that come when you have done time to prepare you for it. It's a battle you fought. Often, and particularly in these cases, I know the families spent every dime they could to find the best lawyers they could to try to defend their sons. So they are broke and broken. 2 men who were in their teens were incarcerated for the bulk of their life. My children are near their ages, and I often think about what we were doing in Floyd County at the time of their arrests. It wasn't a story that hit my radar because I was busy being a mom. But they were finishing high school, going to college. They both now have careers. They've given us 7 grandchildren, happy marriages. Those are things that particularly the 2 men I'm going to talk about in a minute have not had the opportunity to do. So when we look at House Resolution 128, it combines the claims of the 5, as you said, and part of that was because of time and timing as we go through this. This is not a subject that hardly anyone wants to be a part of talking about. It's not something you want to do. It's not something we are prepared or equipped to do. Trials take place with a jury in a courtroom. I understand that in the House and the Senate, we look at this process very differently, and as has been stated over and over again, there's need for a very, very different process. But we look at the claims today of 5 of our fellow Georgians who were wrongly prosecuted, convicted, and incarcerated, who presented evidence of their innocence in a courtroom, not in one of our committee rooms, in a court of law, and who were exonerated on the charges that jailed them for decades. They now seek compensation from the state as a meager recompense to help them pick up their pieces of their lives that were shattered by their wrongful conviction and incarceration. As we begin, I want to say this, that my heart aches for the families that lost loved ones. I only know about my 2 stories. I really have not read the other 3. The other you will hear about from other members who represent them. My heart aches for anyone who lost a child in any way, especially in a violent way. And I think we must remember that. I am so sorry for Mr. Dawkins and for the pain that he has obviously experienced. I know what it's like to grow up in a Georgia Power family, too. I know he was a good employee. My dad was with Georgia Power. I grew up in that family. And there's a plant in Georgia named for my father. I would do anything for Georgia employees, Georgia Power employees that I ever could. This resolution, which passed the House by 151 to 12 vote, combines the 5 separate claims, as I said, 2 from my community for Darrell Lee Clark and Joseph Samuel Watkins. 2 are sponsored by Representative Stacey Evans from here in Atlanta for Mario Stinchcomb and Michael Woolfolk, and 1 by Representative Amari Crawford for Cedric Moore. The procedural background for each of these claimants is contained within the resolution that's before you today. We have had wonderful testimony this morning about the process, about where it is today, about why. I think from Robert Smith, from Maggie Hasty, having interacted with them on the steps through this, it's important to realize how hard this is for the Secretary of State, as well as how I think Robert stressed that the process that he goes through in the courtroom is respectful. It is a burden to prove, as it should be, and occasionally, to quote him, he said, we get it wrong. And that's what we're talking about. We are talking about claimants today who were exonerated, each one based on new evidence. These are not mistakes. This is new evidence, not multiple bites at the apple, not an assumption, but a reality. Today, they are innocent, proven by the courts. If we are the court, then I guess we can change that. The resolution process does not require innocence. The process bill that we'll talk about in a little while does require that, the one that the House has written and has actually in rules right now. So when people are disturbed and harmed by our criminal justice system, I personally believe that we owe them more than a "we're sorry," that pat on the back and here's your freedom. I think you probably do too. I've seen that. It's been demonstrated when the Senate voted unanimously to pass Senate Bill 244, which we've attached HB 533 to. The state can harm people without prosecutorial misconduct, and that harm should be equally recompensable, because intentionally or not, the state caused that harm. Allowing criminal defendants to be compensated when their prosecutor is disqualified by a court of law is very important. You'll see that in 244 that y'all passed. That legislation is important to all of us, I do believe. Compensation for a wrongful prosecution that results in a conviction and years behind bars is at least as worthy of a cause.
Representative Dempsey, real quick, you said 244 that we passed. What is 244?
244 is Senator Beach bills on criminal procedures for,
Okay, that's the DA.
criminal defendants to be compensated when their prosecutor is disqualified.
Okay, and so what you're saying is that you've added language to that does this. The bill we passed out was just the Senator
It
Beach's
was.
language?
That's
Okay.
right.
And that's
And-
over in House rules now? Or-
It is. It is
Okay,
passed out
right.
of judiciary.
Right.
With Senator Beach and I both defending it.
Right.
He's asked for it in rules. So,
He being Senator Beach?
yes,
Your thumb went to the guy sitting on the end, so
Yeah,
I was just curious.
absolutely.
Yes,
We're in the process of that.
thank you.
So, before I get back to talking about the 2 individuals, I want you to know that 4 of these claimants presented their claims during the last biennium, where they received committee action in the House and passed on the floor, and received a standing ovation for it, actually. but they received no committee action in the Senate. So it's not lost on me or anyone here that today's hearing can have no productive result this year either. The Senate's deadline is passed for consideration of this resolution, which begs the question of why are we here since we have to start over again next year in the House with resolutions and then bring them back again, and we'll all be right here unless we change that process. I can tell you why I think we aren't here. We aren't here to relitigate cases that have already been decided by a court of law. A court of law with an impartial, elected judge with rights for the accused and the accuser and the victims to be heard, with rules of evidence, with cross-examination, with all the protections we provide, and trust to determine guilt. But that we apparently don't trust to say they got it wrong. Each of these men have appeared again before a court of law, and the court was held that their convictions cannot stand. I strongly feel that any determination otherwise is frankly not ours to make. That's because as legislators we are elected to legislate, not to adjudicate. Yet I'll admit the compensation resolution process enables and perhaps even encourages us to take on a judicial role. It's not our place. And there's a better way, one that lets legislators be legislators and judges be judges. So we're back to where we started, with 5 of our fellow Georgians who were wrongly prosecuted, convicted, and incarcerated, who subsequently presented evidence of their innocence in a court of law, and who were exonerated on the charges that jailed them for decades. And today, this meeting, I hope, will help them move on with our lives and will help us move on with a better process. To speak to the resolution. In part 1, for compensating Joey Watkins, and if I may, Mr. Chairman, because I know there could be questions that could be very specific, I would like to ask your permission to call Cameron Watkins to come sit up here,
Absolutely.
the lawyer that's
Absolutely.
worked on it, so that it's not just Katie. I'm probably the only non-lawyer in the bunch sitting behind me on these, but I would like to do.
That's not a bad thing.
It's not a
That's
bad
not-
thing.
that's
No,
right.
you're absolutely right, but they are very smart.
They
And I
are.
appreciate my fellow members back here. So Joey's case goes back to 2000, January of 2000, when he was 18 years old. The cell phone location data which came forward showed that he could not be at the scene, and that is what actually proved his innocence. There are several steps that Mr. Roberts can talk to, but they involved juror misconduct, buried evidence, and false testimony. If y'all have questions, I would like, between the two of us, we can answer them. It is laid out in a very specific and concise resolution here. The cases, though, are available to each of you to read in full detail, should you need to, and they are heartbreaking. I will tell you that. I decided to serve because of a case that took place, not on murder, but a truly life-changing case for a friend in Roman Floyd County, just about the same time, with some of the same people that were involved in their prosecution, both of these prosecutions. They're very intertwined in the prosecutors. I sat, my friend, as he reached the very end of the statute of limitations, finally got a jury trial. Never put in jail. He was released on bond. But after almost 7 years, I sat and listened to every word of the trial. And in 1 hour, the jury went out, which is always a scary thing. You think for sure someone's guilty if they were able to come to it that quickly. And the lawyers that were there, which were not from Floyd County at that time, asked me if I would speak to his character, to ask for leniency of his court. He was a father of young children, a good husband, and a really strong, good person in our community. And I was prepared. I'd never done anything like that. I was prepared to do that. But they came in and they found him innocent. They found him completely innocent. And many of those jurors have talked to me about that case and other people they knew that were going through processes at that time. It was a unique time in my community, I will say that. I think our judicial system is much better today than it was at that time. I'm not a judge. I was not a juror. I'm not a lawyer. But I witnessed something that made me feel that I had to be a part of changing things. That was why 19 years ago I ran for this office. And that is why I continue to serve my community, is to serve, not to judge. I will be a juror when called, and if they ever put me on a jury again, because we all know too much now usually to be allowed to do that. But I knew at that time it could be better, and it is today. And I am grateful for the processes that allowed for these 5 men to have this opportunity, and for the process that I think we have to help each of them live a more productive life again. And if there are any questions, I'll be glad to answer them.
Thank you. I just was going to ask, in the case of, I believe it's Mr. Watkins, you said cell phone data
Yes.
had been used. Are they able to go back and retrieve cell phone data from 25 years ago? I'm
Happy to speak to that, Senator. This is Cameron Roberts. I'm from Kaplan Cobb, representing Joey
Cameron, check
Watkins.
that mic next to you to see if it's working, so you don't have to share.
Happy to do that, too. Thank you,
Yeah.
Mr. Chairman. The cell phone evidence was presented at the trial originally in this case, and it, played an important role in the Supreme Court's affirmance of the decision to overturn Mr. Watkins' conviction. And if you wanted to learn more about the cell phone evidence, I think the Supreme Court's opinion in this matter is very important, and that's where I would kind of refer you to look.
But it's the data that they had 25 years ago. So 25 years ago, we had the technology for them to be able to geolocate people.
The way I would describe it, and I'm not familiar with exactly what was available 25 years ago, I think maybe stepping outside of Mr. Watkins' case, I know there's been improvements in 25 years on what you can do with that kind of data, and I think what those improvements, can show things with that weren't available 25 years ago, but there was data present.
Is it because 25 years ago, and I've got a good friend in the back from the GBI, I know we were able to ping cell phones, ping towers. And was the evidence brought to the Supreme Court in seeking a reversal of the conviction that data back then was not as precise as what we have today? It was a little more general, if you will?
I don't know the answer to that exact question, Senator. What I would say is that the Supreme Court's opinion goes through what cell phone record evidence was before it,
Right.
in that opinion, and I think it summarizes and does a good job of showing how Mr. Watkins couldn't have committed the crime. And to me, go ahead.
Yeah, well, my understanding, and Representative Dempsey testified to it, that new evidence. So what is the new evidence related to cell phone?
So that wasn't the new evidence that was used by the
Okay.
Supreme Court. The new evidence, there's several pieces of new evidence in Mr. Watkins' case.
The
but
GBI log
That's
book?
one of them, yes,
Okay.
sir. And then also, the evidence of the juror's testimony
Right.
wasn't available.
Right, and I want to be clear, the juror misconduct, as sadly it's called, even though I think many times when there's juror misconduct, it's unintentional, whether it's violation of sequestration or something. But the juror misconduct was what we had heard before, I think, when somebody testified. I think it may have been Mr. Dawkins testified to the fact that they had taken a break on the weekend, and the juror actually drove the route that he or she had heard in the trial as being the route that the accused took, and the defense said by driving that route, they would not have enough time to commit the crime, and the juror drove the route and came in and basically infected the pool by telling them that, or not the pool, but infected the jury by telling them that she had driven the route, and her experience was counter to what the defense had presented in court. Was that the third piece of evidence of juror misconduct? And I don't mean to do an air quote on that, because that's exactly what it is. I mean, based on the court, so.
I think the one piece that I'd add to that is that the Supreme Court found that she did not even drive the correct route.
Oh, okay.
So it's not that she drove the correct
Right.
route and then she was countering that with evidence.
Right.
The Supreme Court found that she wasn't even driving the route.
Right.
that-
But her misconduct was to go out there and drive that, then come back to the jury and say, hey, I drove it, and it's, no matter what route she drove, it's improper for her to come back and basically introduce evidence
I would agree with you about
into
that.
the, yeah. So I just wanted to be clear. So the cell phone thing was, I'm just still, to Senator Goodman's question, cell phone technology that far back. I mean, there were times that we'd have to bring in the U.S. Marshals to track cell phones 10 years ago, and, well, 15 years ago in certain cases. So were we using antiquated technology that kind of discounted the cell phone data that may have been used at the trial? And I have not read the portion of the trial that deals with that, so I'm asking that question out of complete ignorance.
Let me say, I don't know the answer to that
Yeah.
question in Mr. Watkins' trial. What I'll say in general is that I think everyone's familiarity and how to use evidence, and I mean, this has been true in my practice too, that, in 10 years that I've been a lawyer, lawyers have gotten more experienced with cell phone evidence, what it means, how to use it, how to rebut it. Whether that played a role in Mr. Watkins' case, I can't speak to that, but I will say the Supreme Court, and it's actually the case if you watch the oral argument in the Supreme Court's hearing, you can see, especially I'd say, Justice Pinson and Justice Warren have a lot of familiarity with it, and they, I'd say, are pretty expert in walking through
Yeah.
the opinions by Justice Pinson, and pretty expert in walking through how this evidence shows he couldn't have been there. And to speak to that for a second, I mean, that's in what they call the prejudice prong of their analysis. Senator Robertson, I think, when Mr. Smith was presenting earlier, he made the point that you don't get a conviction overturned just because there was an error. There can be things like overwhelming evidence that show
That's right.
that you weren't prejudiced by the error. Here, the Supreme Court found that the evidence against Mr. Watkins was weak, and with a cell phone was part of the reason why, and that's why they overturned the conviction.
Yeah. And real quick, I messed up on an administrative thing. Would you identify yourself and who you're
I'm
with?
sorry, yes,
Yeah.
I'm Cameron Roberts. I'm from the law firm of Kaplan Cobb, and I represent Mr. Watkins. Well, I represented him before the Claims Advisory Board.
Oh, okay. Okay, good deal. And represented him through your law firm?
Yes, sir.
Yeah, okay. Any other questions related to that? And are you more familiar with the cell phone evidence now that you've done this and gained some experiences to
Yes, sir.
to the value and invaluability of it? Yeah.
There is value to it. I mean, like I said, in Mr. Watkins' case, my view, and I think the views of the justices on the Supreme Court,
Yeah.
show that cell phone evidence is often used because it's inculpatory, and it shows someone was where they shouldn't have been, and that
Yeah.
supports their conviction. In Mr. Watkins' case, I think the cell phone evidence shows that it is exculpatory evidence.
Okay, so the new evidence that Representative Dempsey was discussing was the cell phone evidence, the juror evidence, and then the third piece would have been the log from the GBI?
Yes, sir.
And could you explain that log briefly?
I guess what I would say about that, and again, more details can be found in the records that
Right.
were before the Supreme Court and otherwise, and I think it's difficult to summarize all those things, but new evidence was found regarding ballistic testing and a log of ballistic testing in Mr. Watkins' case, and that when that evidence was found, it was determined that the state hadn't provided that evidence, and that in fact, a GBI officer had given false testimony about the existence of that evidence at the trial, And again, I'm summarizing kind of greatly here, so forgive me. What I would say is that those two findings were also grounds for the habeas court to overturn the conviction. So it's been mentioned by some other witnesses earlier that juror misconduct was the only ground. That was the only ground, or those are three grounds at the habeas court for overturning Mr. Watkins's conviction. The Supreme Court affirmed only based on the first ground and just didn't reach the other grounds, which is common in legal proceedings.
Okay. Has Mr. Watkins, has he filed a 1983 action?
He has not.
He has not? Okay. The dog mentioned in one of the files I read, is this the dog that Mr. Dawkins spoke of earlier? A bullet from a dog?
I don't know what you read, Senator, but
Apparently
that
there
is
was-
part of the case.
Okay,
yes,
so is it, are we talking about the same dog?
I'm not sure which dog
Okay.
you're speaking to.
The
but
dog that Mr. Dawkins says was shot in his backyard that belonged to his son?
that is part of the case file, yes.
Oh, okay.
Yeah.
So, okay, because I thought the second bullet came from,
You're speaking of the ballistics test?
Correct.
I believe that's right.
that's right, so the ballistics came from the hunting dog in the backyard. And I think their attempt was to compare the bullet used to kill the hunting dog with the bullet that was used to possibly shoot Isaac with. And I think there was a shell casing recovered from the road that had been ran over or something, and I think that was part of the ballistics work in the, and as with, and of course I'll accept challenge because again there's a lot of smart people in the room. Ballistics, as much as CSI and every other junk show on television likes to make it seem as precise as it can be, ballistics, cell phone evidence, unless it's Find My Friend for the most part, and a few other pieces of evidence are not exact. It's all the evidence together that tends to pull the case together. But so the ballistics part, I know there was some. I think the separate log is I think that's important to show that there was a second bullet there, and reading the case files where I found the dog at. So.
And I guess what I would say to that too, just to maybe make one more point, and
Yeah.
that is related to the points that Mr. Dawkins was making about the dog. These are complex issues, and again, I think I agree with all the comments that have been made this morning about the limitations of this process for judging the evidence about those issues.
So who chose not to retry the case?
I understand that to be the district attorney's decision.
Right. We had the one witness, I think it was Mr. Cook, that came up and said the judge chose not to, and then the DA chose not to.
I believe Mr. Cook was mistaken. The court overturned the conviction.
Right.
That decision was affirmed by the Supreme Court. My understanding is it could have been retried, but District Attorney Patterson null-prossed the case.
Null-prossed the case, okay. And so I guess in real world terms, the case is still open, right?
I think it could be retried.
Yeah, okay. All right.
Mr. Chairman?
Yes, sir.
This could be a question for you, but
Yes, sir.
did the ballistics match between the two?
Two different types of firearms were used, I do believe. I believe the round used to kill the dog was different than the round that was recovered from Isaac. And it's uncomfortable to talk about it with his dad sitting in the back of the room. I appreciate him. We don't want to give you the impression that we're talking as if you're not here. But yeah, it was two different calibers is the best of my recollection. Don't hold me to that, but it was. And I think the shell casing found in the road was from a 9mm, I believe, that had been ran over by traffic. But Representative Dempsey, anything further on that particular one?
That's the same information I have about the dog incident
Yes,
as
ma'am.
well, two different.
And I do want to say this, and I know you brought it up earlier in your testimony about the, that we looked at this last year, and in my conversation with Maggie, and I appreciate you recognizing Maggie, because I think we're dealing with her, people don't appreciate the position that they're under in the Secretary of State's office. But when I sought clarification on a timeline when these had to be done, I was told there was no timeline. So, because when I first was elected to the General Assembly about 7 years ago, I think my second year in or third year in, somebody brought up a 2-year, that we had 2 years to do this. And when I reached back to the Secretary of State's office, I was told that was not the case.
And I hope that is correct. I will tell you, I'm not 100% sure on that.
Yeah.
But what the timeline is that that's 2 less years that these men have been able to move forward in their life. So, I mean, while we can say we have X amount of time, they're at a place where they don't have the life experience, the family, or the monetary ability to kind of move forward in a lot of ways.
I appreciate your passion to this, I really do, and I consider you a friend, absolutely. But when I go through these, I have to do what I did for 30 years. I have to unplug my heart and look at things in black and white. That's the reality of it. Title 16 and Title 40 did not give me the ability to police outside of the rules. Just couldn't do that, no matter what. If I walked in and there was a domestic violence case and there's a lady sitting on one side of the room with her face beaten bloody and there's a guy sitting on the other side of the room with his knuckles bleeding, I could not make judgment. My responsibility was to make sure both received first aid, that all of our reports and notes were done correctly. I couldn't let the fact that I was raised by a mother and sisters roll into my opinion. I couldn't let the fact that I abhor violence against women and children roll into that. I had to do what I had to do, or I was going to take a really good chance of losing justice for somebody who had been mistreated. So I got myself conditioned through that time to look at everything through very black and white lenses. And so as we go through these, I try to do the same thing. I don't think this could have happened to me. I really don't, because the life I lived and the life I attempt to live today doesn't allow me to find myself in situations where I can be wrongly accused of murdering somebody, of where there's any evidence at all that I'm involved, that there's any evidence at all that I've made threats to kill people or to do all this. I do believe that people put themselves in gray areas sometimes that may get them falsely accused of being in a darker place, and that is not right. Nobody who has not done anything should ever be tried and much less convicted of something they didn't do. But it goes back to the fact that if you look at a lot of the laws around the state around the country that deal with wrongfully convicted people, there are several of them that have some very strong clean hands requirements, where not only can you not be the actual perpetrator of the crime, but you can't be a party to the crime, and several other things that go out of there. So while we agree that wrongly convicted people that are innocent, that are actually innocent and determined to be innocent by the courts, deserve some type of reparations. While we can agree to that, we still continue to drill down to find out what is exoneration. Is exoneration a null pros, where the prosecutor says, you know what, I know this guy did it, but I don't have enough evidence to go back to trial. It's been 20, 25 years and witnesses are dead and investigators are dead and other things. So walking through this, seeking reparations and justice for the wrongly convicted, while I think it's something we should do, I think it is something that we have to do very light on our feet so that we don't step on the many mines that I think are planted around this subject matter. But I do appreciate your passion, but I do think we have to be careful. And I do not believe that this could just happen to anybody. I really don't. And
Well, we disagree on that because I
Right.
think it can. And I actually think that because of the roles that we play in government, we're probably more vulnerable to that, to someone that might get mad make something up, especially in the world of AI today,
Yeah.
that I think we're very vulnerable.
Well, I feel very protected by the criminal justice system because I understand due process, and I think through due process, I would be able to exonerate myself fairly quickly.
And that's what they have done.
Thank goodness for Find My Friend. Well, and again, we get to exoneration. It was an all pros. It wasn't, and we had an exoneration here, I want to say a couple of years ago here in the Atlanta area where a pair of glasses were left at a murder scene and DNA was not collected, and once it was, the wrongly convicted person was released, and the person who actually committed the murder based on the DNA evidence was prosecuted. And that is a clear case of exoneration. And rarely are we going to run into such a clear case, but I think we have to use some standard to get to that point. But on the compensation of the gentleman here, what I noticed is the compensation was directed toward the GBI. It was not the Department of Corrections or, let's see, the exoneration requests were made against the Floyd Police Department, which Maggie stated was not a state agency, so it could not be directed there. Non-payment in a 3-0 vote was not recommended for the Georgia Department of Corrections, and in a 4-0 vote, payment was recommended to the GBI. Is that correct?
That's correct, Senator.
Okay, thank you.
And,
I appreciate it.
You know, I think the approach, of course, is kind of, as a typical lawyer, cover all your bases, include
That's right.
everyone. But, of course, we included the GBI in
Yeah.
this case because
Well,
of their special role here.
In South Georgia, we call that fishing with dynamite. It's what we call it. You throw it in the water, you're going to get something. Yeah. But, no, that's good. I appreciate that. All right, and do you have one more?
I do. Part 2 begins at line 112 in the resolution. And if I could, I would like to ask Paul Murphy to come sit with me for any questions that might come up in the process.
Welcome, Mr. Murphy. If you'll identify yourself and tell us who you're with, I would greatly appreciate it. And I've got mic 3 on for you right there.
Good morning. My name is Paul Murphy. I'm with myself. I'm one of those pro bono lawyers who was been extolled earlier by Mr. Smith this morning. I'm not from New York, and I don't have my own personal printer, but I am representing Lee Clark in connection with this matter here today.
So to talk a little bit about Darrell Lee, and he goes by Lee Clark, and his case, he was 17 years old. It was felt at that time that this was a game of Russian roulette, but he did go forward and spend a great deal of time, 25 years in prison, actually. He maintained that he was innocent, and a witness placed him there was proven to not be telling the truth. The basis for the compensation came from a sexual relationship. The lead detective was involved with a family member, manufactured evidence. I believe that you've heard about that. The man who was deaf, mute, severely learning impaired, and who did not use standard sign language. So it was very hard to get clear testimony. It came from witness intimidation and coercion, from false testimony, and as what you heard about earlier, Brady violations. The state suppressed exculpatory evidence. The information is very clear. I know none of us have time to read anything extra in the whole wide world right now, but the cases are shocking. I will just tell you that. And this, too, is one of those that was apparently involved in the podcast. I have met the podcasters when they were in Rome for the International Film Festival that Mr. Cook spoke of earlier, but I have not watched any podcasts probably in my whole life.
I'll be honest with you, I didn't know you could watch podcasts. I thought you had to listen to them.
Listen, whatever. You can do both.
Yeah, can you do both?
You
Yeah.
can do both. You
See,
can.
yeah.
Yeah, you can.
They'd get me for distracted driving if I tried to. What evidence was suppressed by the state?
First of all, let me just state, I agree that there's a far better place for matters like this to be adjudicated, and that this is not the place for it to be adjudicated. In America, we use the courts for that purpose, and I would refer this panel to the record in this case, which shows what was withheld. Would also show the evidence that was not presented at trial and was presented in connection with his emergency motion for new trial and for his in connection with his petition for writ of habeas corpus. Those documents and that evidence would show that the case was dismissed after the district attorney considered that motion and submitted a consent order along with his counsel to the court to dismiss the case. Lee's convictions were vacated, and he was set free and exonerated on that day. And I would refer this panel to the record in this case, which is the best.
Okay, so the answer to the question is read the record?
Yes.
Okay,
That's
that's a fair response. I've got ring binder of ring binder on this particular case, so I can do that, and I appreciate that. Real quick, and if you do recall, I know that the 15-year-old Mr. Bowling, the allegation is that there was a game of Russian roulette with he and another friend, and does anybody know who introduced the firearm into the Russian roulette?
Again, I would refer to
Okay.
the record in the case.
I do appreciate that. And do you know if a 1983 has been filed in this case?
It's my understanding that a 1983 action may have been filed in this case.
Has been?
Yes.
Okay, thank you. All right. And I'll let committee members know that I do have records on, I know this case here and the first case. And I'll be happy to share those with anybody that may have any questions. Does anybody have any questions of Ms. Dempsey or the attorney? Okay. As always, I do appreciate you, and I appreciate teledentistry too. So.
I hope so. Kind of getting down to the wire.
Yes, ma'am.
I would like to come back after the other cases are presented.
Yes, ma'am.
And see if we can talk about solution.
I've got this room. Let's see. I've got this room for about 2 more hours, and so we can do that. But if also, I'm not opposed to sitting down with you and have a conversation about the legislation that's moving through now, and just get your thoughts on it. And
I think it'd be great to have it while you're having your hearing. Too,
Sure,
so that
absolutely.
we can talk about it. And I don't think we'll need 2 hours.
oh no, I don't. We just still have other people to talk to. Is what I'm saying. We have other individuals in the compensation resolution that we're going to have to get through also.
Okay.
Yeah, before we get to that point.
Thank you.
Because I need Ms. Evans to come up here and yell at me for a little bit.
Thank you.
Thank you, sir.
You need me to come up and zealously advocate my position, I'm sure, is what you meant, Mr. Chairman.
Yes, ma'am. In South Georgia, that's
Yeah.
exactly what that word means. Yes, ma'am. You're much more articulate than I am.
I don't know about that. Well, I appreciate the time. I have parts 3 and part 4 of the resolution relating to Mario Stinchcomb and Michael Woolfolk, and I'll just have a brief statement about them and then be happy to answer any questions that you or the committee members have. Mario Stinchcomb was actually the first person exonerated through the work of the Fulton Conviction Integrity Unit. They were able to find that he had shot in self-defense. He had maintained from the beginning that he had acted in self-defense. Physical evidence had always supported that he had acted in self-defense. But what led to his emergency extraordinary new trial motion and its ultimate granting was the finding of a key witness to the murder that at the time of the trial was believed to be dead. There is evidence that someone in the prosecutor's office found that out before Mr. Stinchcomb and then Mr. Woolfolk did. But in any event, 14 years after their incarcerations, Mr. Stinchcomb's lawyers were able to figure that out, and they were that was the basis of the motion for new trial, which was granted. His sentence was vacated with consent of the prosecutor's office, which I think is important to know. And we've talked a lot about null process today and what that means or might not mean. And I think it's important for the committee members to know that in the null process for these gentlemen, Mr. Stinchcomb went first, Mr. Woolfolk went second. They were all involved in the same incident. The null process in those cases not only say that the prosecutor is seeking a null pros, but also says that the defendants acted in self-defense. So it's not that they're saying evidence is too old, too much time has passed, this person has gone away, memories have faded, all those things. They said they acted in self-defense because that's what the later found witness was able to show. And the Supreme Court, in their infinite wisdom and in a long opinion that hopefully you'll have and you've read, found that would have been a game changer for the trial, and that's why they granted the new trial. That's why the prosecutor said, not only do I want a null pros, but I want a null pros because this was self-defense. So they were exonerated. And 18 years in prison for crimes they didn't commit, times missed with family. There's no way we can give them that back. And we just humbly ask for what we can do, which is a little bit of compensation through this resolution. They were also two gentlemen that were part of the efforts last year. And appreciate the time. And I know there's some members on this committee that were not there. But it's been a long time coming, as the song says, and I know any of us would have been happy to talk about this in the off season and not the last week of this session. But I'm glad that we're here. Appreciate the time and attention, and I'd be happy to answer any questions.
If Representative Evans, if and please correct me if I'm wrong, was one of the reasons, was there something I remember from last year to where the prosecution failed to include a lesser charge option for the jurors in this? The lady behind you is doing this, so I'm assuming.
Yeah, if I could bring up
Yeah.
Lee,
Yeah.
who's the attorney who might be able to answer that. That is outside of my.
I don't think that's
information.
American Sign Language, but I completely understand it.
That one is on right there.
Yes. Good
Okay.
morning. My name is Lee Schroep. I'm from the law firm of Shine, Brandenburg, and Schroep, and I represented Mario Stinchcomb at the extraordinary motion for new trial, and then Mr. Woolfolk just kind of by default. No, there was no issue with lesser included. Their exoneration, the grant of the extraordinary motion for new trial is based, it's a very simple case.
Right.
The story and the ballistics all line up. It's just whether or not it was in self-defense. And it was solely based on the location of the one witness who could see everything and confirm.
And the one witness, was that the driver of the vehicle?
Yes.
Okay, because my recollection, and please feel free to correct me, the lady was up in the apartment, some type of argument happened. She was involved in a particular form of vice. She left there, went downstairs. The vehicle was down there with her friend driving. She started shooting up at the balcony of the apartment where your two defendants would have, or your two clients would have been. Your two clients retreated into the apartment, got their firearms, came out and started returning fire down to where she was. They fired at each other. She got into the passenger side of the vehicle. As they exited, she and the driver, as they drove off, a shot went through the roof of the vehicle and struck her in the head. And she died from the gunshot wound. And then a little ways down the road, the driver of the vehicle stopped, removed her from the vehicle, placed her on the side of the road, and then exited. Is that close to right?
It is close to
Cool.
right.
I didn't think I would be exactly right.
What the driver of the vehicle, who was the witness, what he really added, which was what was critical, is when she got in the car, she was still leaning out of the car, shooting at him as he drove away.
Right.
And it turned out that the fatal bullet came from Mr. Woolfolk's gun, but he shot back,
Right.
defending himself.
Right.
They, in fact, did not know she was hit until they were arrested because she was in the car and drove away.
Right. Okay, so, and you presented this case to the Compensation Committee?
Yes.
Okay, and on Mr. Woolfolk and Mr. Stitchcomb, they voted 2-1 not to compensate? Is that correct?
Yes, but for both of them, they had a statement about they just don't think that the Department of Corrections did anything wrong, but they believe that if the General Assembly finds that they were wrongfully convicted, that the amount they were asking for was within reason. I don't have the exact language, but it was something like that.
Well, do you think, and I'll direct this to the representative, do you think that if the mechanism we have in place says they should not be compensated, that we as legislators have the ability to compensate anyway?
Absolutely, we
Okay.
do. And I think, Mr. Chairman, Maggie, and I apologize that I forgot Maggie's last name, but
Hasty,
Ms. Hastings,
yes, ma'am.
what she said to us is that that's the process by default because they don't have anywhere else to go.
Yes,
But
ma'am.
all they can do is decide whether or not a state agency did anything wrong and should pay. And so they are looking solely through the lens of what did the Department of Corrections do. Neither one of us are up here saying, and neither of these gentlemen would say that the Department of Corrections is responsible for their wrongful conviction. And so this is the process. We are the process. I really wish we weren't, and I think probably everyone in this room at this 4 hours in probably wishes that we weren't.
Right.
But we are. And so, and it's with all respect to Maggie and the work that they do, and I think she acknowledges it very well. They have a limited lens and a limited amount of things that they're able to do, and it doesn't allow them to do this process. We are the process.
Right, and one second. Representative Dempsey was talking about a 151 to 12 vote, and I mean that's strong. For that many people in the House to agree on something, that's amazing. But
Twice.
twice, yeah.
Generally the same numbers twice.
Right, but what type of presentation did they receive? Did they receive the same type of presentation that would have been offered in front of the Secretary of State's board?
Well, it's a different process. Again, Mr. Chairman, the Secretary of State's process is only looking at, did a state agency mess up?
Right.
Did the Department of Corrections mess up?
Right.
And I would submit, Your Honor, Mr.
Yes.
Chairman, it's
Yeah.
occupational.
Let me make a note.
I forget sometimes where I am,
Yeah.
and it just slips out.
See, I could see. Are there any judges in the room? Okay, I just want to make sure.
But the House, because of the great work of several folks behind me, the House has spent a lot of time thinking about this process and how we compensate those that were wrongfully convicted or whether we do. So we in the House as a body has been educated for over the last probably 8 years, if not more, on this process. And for these particular individuals, this year went through subcommittee, full committee, floor. Last year through the same process. So I don't know all that goes on at the Secretary of State's process,
Yes, ma'am.
but it is different. And I would put the information and the process that we've been through in the House and now here up against any to say that we're doing the best that we can. And it's not even that we're doing the best that we can. I think we're going above and beyond because we shouldn't be looking back really behind the court. We're not equipped. We don't have the same processes they have, but we do have, and I can speak only to my two individuals, the prosecutors consented to a new trial. They said no pros for reason of self-defense. I don't know what else we could possibly do to say these two gentlemen in this system that we have were wrongfully convicted.
And these were not the same prosecutors that had prosecuted them 15 years ago, though, correct?
I would assume not.
Right.
But it's the same office. The
Well, no,
office
no,
speaks
and-
for the office.
Yes, ma'am, I appreciate that. But, you know, what I heard last year, and I think it was maybe the year before last, when we first talked about this particular case, is I think at that time, the individual the driver. And listen, when it first came, and this is harsh, but I think when we deal with these kind of cases, sometimes we have to speak truth, and sometimes truth can be harsh. That she was a sex worker and he was her pimp, boyfriend, whatever. They talked about it. And he was the one that was supposed to be deceased and was later discovered not to be. But and the ballistics in the case file I read were pretty clear on where the shot came from, and it did not. It had nothing saying about her continued shooting as they were driving away. And I know that in certain situations, once the threat is beyond, and we're not talking about a Tennessee Garner type case or anything like that, but once the threat ends, then we are required to our defense stops. And I'm not trying to go behind the court and look at the evidence. The court granted a habeas corpus and sent it down. The court said, and the prosecuting office said, null pros, and I respect all that. But neither one of those took a stand on compensation, and I think that's where the burden, and it appears to be the heaviest burden, gets put back on us. And so that is why I think it's important that we talk about the evidence in a whole. And I certainly don't want to go back and try to figure out what was in the mind of anybody, because the only mind I can think of is whether I'm up on the balcony and somebody's shooting at me and what my response would be. And I think I'm as brave as most people, but my response would be to retreat into the apartment. But I'm not saying that that's what they should do or should not have done. But I think we do have a certain responsibility to look at the case in whole. If we are talking about expending taxpayer dollars into a case where the thing that is set up to address it, and I agree with you, I like your approach. I have respect for the attorney that came up before, but I like your approach of trying to determine where it should go to, and DOC would have seemed to be the logical place to file, and to file there, and then get the non-compensation thing just draws into question. And again, we've got to fix the process, but do we cast the process aside while we're trying to fix the process? And I apologize. Did you have a question, Senator Goodman?
Mr. Chairman, you actually.
I didn't slip up and answer your question.
Well, you did. You provided some insight that I was curious about what the circumstances were of why this woman was shooting at these two individuals. And also, you brought up another point that I was thinking through in my mind of, if somebody pulls up in my driveway and starts shooting up my house, I'm coming out guns blazing. But if somebody is shooting while they're driving away, I wonder. And there again, none of us know what we'll do unless we're put into a situation like that. But it just from my own thinking, and you sort of answered that a little bit, Mr. Chairman, as far as when someone's leaving, and then that brings into the case if someone's leaving but still shooting at you. But then a question as well is if somebody's shooting in an apartment, am I going to go into the apartment and call the police, or am I going to go out there and, you know what I'm saying?
No, and I do. And to the defense of the individuals involved, it's a different mindset on where you find yourself in life. Mm-hmm. Sometimes calling 911 is never the solution, and sad but true. And so I can, as weird as it sounds, I can understand the decisions people make sometimes. Not necessarily respect them, but I can't understand the decisions they make sometimes.
I don't know that any of us know what we would do unless we were put in those situations,
That's right. And if I could respond briefly
Please.
to the exchange, I just want to emphasize again, we're not going around the process. This is the process.
Yes, ma'am.
We're not doing something untoward here. We're doing our charge. And I hesitate to even go here where I'm about to go because I'm going to. I hesitate, but I'm going to. Because I think it's important. We shouldn't be going back and trying to do the court's job. The prosecutors decided this was self-defense because it was, based on the facts, based on the evidence. This victim who died, who whether she was a sex worker or not. I didn't get that into her background, but she didn't deserve to die. We're not happy that she's dead, whatever she chose to do for her living. And just because these two gentlemen might have been at a location with her doesn't mean they lost any less rights than any of us have to defend themselves and their property. And as was acknowledged, we don't know what we would do in that situation. And you think in hindsight, 2020 hindsight, it's a beautiful thing. I'm great at basketball, from my couch. Would you run in? Would you call the police? All the things that we know are true about calling 911, how long it takes, whether they'll come, all the things. But I also just think logically, I can put myself in exactly their situation, and she's driving off and she's shooting, which is what this witness said. I might be able to retreat into my house. How flimsy are those windows? Where are those bullets going to go? Are there children around? What do I need to do to stop the threat? The law gave them the right to do that. The prosecutor's office acknowledged that. That's what led to them being found to have acted in self-defense, and that's what led to the exoneration. And I don't need to know any more than that, Mr. Chairman, for us to do our job.
I appreciate that.
Yep.
I do.
Thank you.
Any other questions?
That's just very, to your point, she's the one that shot first.
Exactly.
I mean,
She was. According
Thank
to
you.
the witnesses that were alive.
That's right.
Thank you. Thank you, Ms. Evans. Excuse me, Representative Evans. Yes, ma'am. Good morning.
Good morning. How are you?
I'm well, and you?
I'm doing fine. Thank you. Thank you for having me. Thank you for allowing me to testify before the committee. The portion that I'm going to be testifying in regards to this particular bill is in Section 5, and it should start line 364.
And I believe, and correct me if I'm wrong, this is a new compensation request?
Yes.
We've never heard this one before.
Correct.
Right?
And I'll be happy to give you some brief facts once you have
I
found
would
it.
appreciate that. Thank you.
All right. Thank
And
you.
This is you.
All
Yes,
right.
sir.
Mr. Cedric Moore was arrested and wrongfully convicted for a crime that he did not commit. He spent approximately 22 years of his life behind bars. And because of advancements in DNA testing, it was found that he was completely innocent, and thus he was exonerated, and the prosecution dismissed the charges against him.
Now, in this case, I think where you said there was DNA, and this was was this a home invasion and a sex crime?
There was a home invasion that took place in 1993. There was a sexual assault, correct?
Right. And the sexual assault, the DNA led to another individual, is that right?
That is correct.
Okay.
And
I'm sorry. Go
And that
ahead.
individual, he made a statement against Mr. Cedric Moore.
Right.
And then again, after he was convicted, after Mr. Moore was convicted, there was an advancement in the way DNA was tested, and it came back that the defense, as well as the state, concluded that the DNA should not have been considered, and that's what led to Mr. Moore's exoneration and the charges dismissed against Mr. Moore.
Now, there were three individuals. The victim said there were three individuals at the scene, correct?
And you are correct, and the victim also testified that she did not identify Mr. Moore.
Right. At the scene was Tyrone White, Cedric Moore, and Kerry Robinson, but the one that the DNA came back to, was that Mr. Robinson?
No.
Okay. Was it Mr. White?
Coincidentally, Mr. Robinson was also wrongfully convicted, and the General Assembly compensated him in 2022.
Okay. All right. Any questions? Okay. There was a hearing of the Claims Advisory Board on Mr. Moore. Are you familiar with that?
Yes.
Yeah. And there was a 4-0 vote for non-payment. Do you have any idea why?
I,
Is that a question we need to direct to them?
yes, I
Okay.
don't know why they came back
Why
with
they
that.
chose not to? Okay, I appreciate that. Any questions from the committee members? Okay. Thank you, Mr. Representative. I appreciate you.
All right, thank you.
Chairwoman Dempsey, do you want to come back up? Have you already been to rules and back?
No,
Oh,
we're just letting it fall.
I thought you had rules. I'm sorry.
We did, you did too, I think, at 9, didn't you? Didn't you have a couple things in
I
there?
think I did. Yeah.
Yeah. Would it be okay, we're gonna talk about the
Yes, ma'am.
the better route to doing this.
Yes,
So
ma'am.
that we don't ever have to do this again, hopefully.
Would what be
Scott
okay?
Holcomb.
This is Scott Holcomb.
This is Scott Holcomb, who's been a champion of this for a very, very long time.
Representative Holcomb and I have had we've had a few conversations about it, and he's given me several sour looks throughout our relationship together, so I know him and have a lot of respect for him. And
I do
so
too.
hopefully
It's
we
been a
can-
pleasure to work with him on this as
Well,
well.
now,
We
pleasure
worked
may
on
be a
it.
strong word, but he's a good guy.
We worked on it together last year and the year before, and he is just so powerful to this message. And it is, we've had a long morning of testimony. I know y'all have to be tired.
Our
we
day's
can't-
just getting started.
Well, ours is too, but
Right.
still, that's what it is. I would say that this speaks to something else that was brought up, I think, in all of this. I did, and I'm proud of the fact I came with a heart. And I plan to leave with that same heart when I finish the work I do. So I do think that, as I said earlier, it could happen to any of us or to someone we love. And that's important to think ahead, to look to the future, to think of a different process. Because would you want someone that you genuinely cared about to have to go through this process? It's not a good way. We are retrying cases that our courts have already adjudicated. If I want to be a judge, I'm going to go get my law degree and run to be a judge or ask for an appointment. I am here to help, and that's the only reason I'm here. So when we look at wrongful compensation, as we said, it's a strong bill.
And what I'd like to do, instead of doing what we typically do, where we say, if you look at line whatever and look at line whatever, let's walk through this process as if it were in place today, and how an individual who the case had gone back and there had been an adjudication or an exoneration, how they would flow through this process. And in any of the cases that we've talked about today can be used as examples or hypothetically, I think, just to make it very clear and plain speak, if we could.
Absolutely. So in very plain speak, it really takes the power away from the legislator to do what we're doing today.
Hear, hear.
And empowers administrative law judges rather than an ad hoc panel to make an informed and, very, very good, educated decision on it. Has much stricter criteria for eligibility and for compensation, and it requires innocence, period. 100% innocence.
How do we
as
do
go.
that?
How do we get to innocence?
How do we require, what is innocence in here? How do we get to innocence? This is somebody that has been convicted and the case has been sent back. Sent back to the court, then how do we get to innocent? Is innocent a null pros?
No, Mr. Chairman. And
Thank you, Scott. I appreciate it.
If I may, I'll give just a little bit of intro, and then we could get into the weeds. So I have been working on this for 4 years. And for those that I don't know well, I practice law. I've been practicing law for more than half my life. And for a period of time, I was a prosecutor as well. So when I was first brought into this conversation was in 2022, or might have even been 2021, and I was asked to help Carrie Robinson. And Carrie Robinson had been convicted of a rape. I've worked for the last 10 years to help improve the state's response to sexual assault. And when I was first asked that question, I did not immediately say yes. In fact, if anything, all of my bias was against helping somebody who had been convicted of rape and sexual assault. I said, I'm open to helping, but I have to do my own homework. So I think similar to what you've done, Chairman Robertson. And so I called the lawyer who helped, I called the prosecutor, I looked into the file, and ultimately it was an issue of DNA evidence. What the DNA found was it was an order of magnitude of the random probability of just somebody walking down the street was thousands of times greater than what was used to convict him. And he went through the Claims Advisory Board process. Interestingly, in that case, the Claims Advisory Board, some of the things you've heard this morning, recommended against compensation. Why? Because they didn't find that the Department of Corrections had done anything wrong. They housed him, as they were required to do after he was sentenced. And then there was changes in terms of the DNA evidence. So the GBI's position was, we didn't do anything wrong at the time. We now know with advances in technology that this person did not do it and so was exonerated. With that, there was also a proposal to change the way that we handle this. Instead of having it be done as it's currently handled, which Georgia is, I believe, one of only 11 states that doesn't have a formal process for handling this. And so for the last 3 years, we had different variations, but the bill was fairly similar, where there would be a compensation committee. It would include a former retired justice, judge, a DA, a defense attorney, and then experts in exoneration. We moved away from that this year, and the proposal that's still alive that hopefully will be able to move would move it to an administrative law judge. And there were two primary reasons for doing that. One is, if you're somebody that was wrongfully convicted, we shouldn't make this somebody else's volunteer or secondary assignment. It should be a primary consideration, primary work objective, and not ask somebody this is a get to, because they all have other jobs. In addition, the judge may need to have some assistance in terms of legal research, reviewing the case file, and our administrative law judges have that capacity and the ability. So let me transition that in terms of background to what we are proposing in terms of fixing the system. Would be that a claimant would file before the Office of State Administrative Hearings. These are administrative law judges who are currently paid by the state. That's another benefit. Instead of having a new commission with payments of it, these people are already salaried and on, so we would give them a new duty. And the law, or the proposed law, the way that it would handle the question of exoneration, and on that, there can be individuals who were exonerated but did in fact commit the crime. Those may involve very legitimate and significant constitutional issues. Sometimes those are described as technicalities, but they are constitutional issues. I'm a former prosecutor. I think every prosecutor has dealt with not being able to convict somebody that you knew did it, but you just couldn't get the conviction for whatever reason. The statute that we propose is very, very clear, and it states that an individual would have to show that the claimant did not commit the crime for which the claimant was convicted and did not commit any lesser included offense. So that's what the administrative law judge will have to decide. It's not a question of how it's characterized. It's not a question of whether it's nol prost. It's not a question of anything in terms of the exoneration, how it's framed. It's what actually happened. And you have to prove that you did not do it. More likely than not, most of these cases will be DNA linked, because that would be the best way to prove that you did not do it. But it could also be a recantation, a change of witnesses, some new technology we don't even know of. But the standard is there that the person has to demonstrate that they did not do it. And the judge has to then create a finding of it. The other big part of it is this. I think the way that people have been treated for this process in our state has been inconsistent in terms of some people get compensation, some people don't. Some people get a certain amount of compensation, others get a different amount of compensation. So what's been proposed is just to take all the ambiguity out of it and have it be $75,000 per year for the time period that one has been wrongfully incarcerated, which when you look at it as a lump sum may look like a significant amount of money, and it is, but at the same token, I don't think any person would trade whatever that dollar figure is for spending 10, 15, 20, 25 years in prison. One of the things I've really learned from spending time with Lee and Joey has been the personal impact of this. Because they were locked up for primarily their 20s and 30s, which, let's be honest, most of us had the best years of our lives when we were in our 20s and 30s. You're young, you have lots of friends, you're going out, you're doing the things that people in their 20s, 30s do. They missed all of that. They weren't able to invest in their careers. They weren't able to save for retirement because you're not contributing to Social Security, and that can't be made up. They have no safety net. They missed out on all of the changes that we just lived through. And then I don't think it's sufficient for an individual to be wrongfully convicted and then the state to just say, we're sorry we messed up, now you go figure it out. The only thing that we can do is to compensate them. No level of compensation is appropriate or adequate or will really make them whole. But $75,000 per year, and there is within the proposal an additional $25,000 for somebody that was on death row, because that's very stressful if you think you're going to potentially be killed for a crime that you didn't commit. And then it would be up to us still, us being the General Assembly, because this would go to a recommendation, and then we would ultimately have to appropriate the fees. So there is still, within any mechanism, the General Assembly is going to have the last say. So if we were to disagree with an administrative law judge's decision, I would think that would be extraordinarily rare, because we're trusting these people to do what we're doing now, but to do it in a setting with rules of evidence, with rules of procedure, and then they have to come up with a written finding of innocence. And if the individual can't demonstrate innocence, they're not getting compensated. And that's a different debate, whether an individual who, but for a constitutional violation, would not have been convicted. We're not going there. We're just limiting this to only those that are truly innocent, and they have to demonstrate it.
That is plain speak, and I think it's well thought out. I like it. Sounds good, and I think it's something I'd like to talk about. Really do. The only thing that aggravates me, and I know it's the same thing that aggravates you, is we've tried to pull ourselves just completely out of it, and as long as there's an appropriation, we're not going to be able to do that. But it is so much cleaner, and because you're right, there's a lot of inconsistencies in the way we're doing things now, and we're asking attorneys from the Department of Transportation and other things to make these decisions, and it cannot be easy for them to do this, or it shouldn't be easy for them to do this. It certainly wouldn't be easy for me. So I do think that's something that we need to look at, and I see a lot of really, really good in that. And I think you've done a great job on this. I know you got an excellent sidekick there with you, and I know he's very passionate about this, and have a tremendous amount of respect for him, and as I do you. Representative Evans just makes me nervous.
She's pretty smart.
Yeah.
She makes all of us nervous,
I know
to
she
be fair.
does.
Yeah.
I know she does. It's the reason I sit with my back to the wall. But I do think it has some legitimate concern, and I'm going to take it forth to the chair and also others, and have a conversation today about this piece of legislation, because I do think it has merit.
Well, it simply establishes a statutory process to fairly and uniformly compensate innocent people who have proven that they were incarcerated for crimes they didn't commit. It is attached, as I said earlier, to Senate Bill 244, Brandon
Yeah,
Beaches.
and look,
which
I
all
was-
passed unanimously.
Well, I want to be clear. Those two things have nothing to do with each other.
Correct.
I mean, we have to be honest in this building, and so many times we're not. I mean, I remember my first session up here, I used to think Christmas trees were beautiful things that I could get presents under when I was a child. And I came up here, and Christmas trees make me nervous now and sweat and all this other stuff. But I think this is something as important as it is, that if this is something we can get moving and get out this session with a conversation, and maybe if any adjustments, slight adjustments, look at it, how we do it, then I'm willing to do that. But I do think it's important that we do not send it out, and I'm going to say this, and it's going to offend somebody, and it would not be a session if I did not offend somebody at some point. But we need something solid and not a bastard son that we send out there. That's something that we can all stand together on and say, we think this is what we need. Because one thing that Representative Holcomb and I have agreed on from the first day we had a conversation about this is the way we're doing things now is not the way to do things. And have a tremendous amount of respect for his work on this, and the fact that he's a prosecutor does bring value to what he's done, because I don't know anybody that would they love the job, but it's a brutal job. And so but I do appreciate that, and like I said, I'll be speaking to the chairman today about this, and hopefully talking to a couple of other people that maybe we can do something to get some things going in the right direction. And but in the real world we live in, if something does get pushed beyond this session, I want y'all to know that I'm committed 100% to help, and I think this is a huge step forward. I really do. And so I do appreciate that. And appreciate everybody's time today. Anything else from the committee?
Just a comment, say thank you for your work, and this is something that you need to do, but I'm just wondering, when you did this legislation, you said, I was just wondering, I was surprised to even see that we are the only 11 states that have any mechanism, so.
Right.
How did you come up with this? I'm just wondering, 75,000, I'm not, just in general, I was trying to figure it out,
It's pretty close to a median average of across the country. There is variation in terms of how states do it. Some states provide much more in terms of what they provide for compensation. Some states provide lifetime health care. Some states provide access to education, free college courses for those. So 75,000 is very close to, it might even match what the federal rate is, and then it's right in the middle, generally speaking, in terms of the states across the board. And two other substantive things, if I can really quickly, Mr. Chairman, members of the committee, is I agree with just about everything that Mr. Smith said. The process usually works. What we're talking about here are outliers. Usually the process works. But I don't know of any human institution that is infallible and never makes mistakes. There are mistakes that are made. There are juries that give their best, but they get it wrong. And so for those, thankfully, small universe of people that are impacted by this, we need to have a better system. And the other points that I'd like to just quickly highlight are the bill has strict timeframes to move these cases along. It has notice provisions, and then it also has, if an individual has a civil lawsuit, Mr. Chairman, you mentioned 1983 claims and otherwise, if they have a civil lawsuit, they cannot double dip. So the bill has a credit function to where if you are seeking remedies through the civil lawsuit, you can't get this. It would be taken into account and a credit would be adjusted. So I think we've covered the bases. We've really tried to get it as right as possible, recognizing that others may have ideas to improve it. But we really do think this would be a dramatic improvement over what we're doing now.
Well, and it moves the needle a little bit. My proposed legislation is very similar to what Florida does. But mine has the educational aspect, piece of the healthcare aspect, and some of the other stuff. But I think this is cleaner, I do believe, to get us to where we need to be. the thing about it is we have to make it as tight as possible because, in the 1983, my concern about that is many of the states that have this, you get to choose. You either choose what the state offers or you choose 1983. There's not both. And I think that's very reasonable to do something of that nature. And as cold as this may sound, the bottom line is too is we have to think about appropriations.
Yes,
And we have to think about, and 1983 claims are outrageously expensive when lost. So those are conversations that as we move forward, we will. I want to thank everybody for being here today. I appreciate everybody. I think, I hope everybody understands that my reputation with having these early morning meetings is I do not like 9 p.m. at night. I'm usually getting my pajamas on and getting ready to go to bed at night because I'm an elderly man. We rush too many things through this building without having legitimate deep dive conversations about it, whether it's schools on speed cameras or compensation. And so I think this is, in my mind, the best way to do this, to really, and I think where we're at today, right now, is a result of that. And so I greatly appreciate y'all tolerating my quirks and my weirdness, and that means a lot to me, and this meeting is adjourned. Thank you.
Thank you.
That's what my children say.